Solid. Good morning, everyone. Uh, Tomorrow we have annual general meeting. So program is from 1 o'clock. So I would request all the members to be present. And all the seniors have been directed to issue bill to their respective members. Attending on this program. Hey. One more information. Maybe life will be provided after the day. For organization of just item number 143 and 144.
Accordingly, it is directed that the respondent authorities shall reconsider the case of the petitioner for regulation of his service by allowing the petitioner to participate in the selection process for ad hoc employees as per the policy of the state and in accordance with the relevant rules and act. The petition is allowed. Next one, same.
Please, my lord.
Yes,
Lordship, I'd like to mention item number 119, 119, Lordship.
yes,
Lordship, I have present difficulty today if it may be listed next week, Lordship. If it is convenient for the Tuesday, Lord. Tuesday, if it is convenient for my lord.
who is for petitioner?
And you have taken the consent, Lordship, which is there.
On the prayer of Mr. Anangami.
Kiangami.
Kiangami. Learned people. This matter on 26, 9/2022.
Your Lordship, for the petition.
MS Swenso, learned counsel. For the petitioner present.
Lordship, then on behalf of MS IME,
How many items you want to mention? Just give the list number.
Lordship, item 62,
Hmm.
112,
Hmm.
126,
Hmm.
on behalf of MS IME, Lordship.
Item
62,
62.
112,
Yes.
126, Lordship, after 2 weeks, Lordship.
100,
126, Lordship.
26.
62, 112, 126.
112, 126.
Lordship.
And
And that is on behalf of MS IME and on behalf of Noah Imchem, Lordship. He is in bereavement today, Lordship. Item 74.
what happened to more?
He's in bereavement today, Lordship. He has to attend a funeral. Lordship.
Okay. 74.
74, 83, 125, 128, 142,
42.
142. 142 counter filed in all cases and after 2 weeks, Lordship.
For filing counter affidavit.
All filed.
Huh?
All affidavit filed. Affidavit filed in all
Mr.
cases.
Swenso Kiangami, London State Council,
Then Lordship,
report listing the matter after 2 weeks. Prayer, list after 2 weeks.
Lordship, then again on behalf of Mr. Tiba.
No, you record his name.
Yes, item
We'll fix the responsibility on him.
139, Lordship.
139.
After 2 weeks, that also.
Then
Then lastly, Lordship, on behalf of MS Imaholi, item number 75 to 78.
just 139.
Yes, that is on behalf of Mr. Tiba.
No, 139 is along with 135.
Lordship, then not Lordship, I beg my your apology, Lordship. 100, not 139, Lordship. Item number 75 to 78. 75 to 78.
75 to 78.
Lordship,
Hmm,
on behalf of Ms. Inaholi, 3
Hmm.
weeks to file counter, Lordship.
hmm. Okay.
Oblige, Lordship.
Please, Your Worship,
Yes.
I beg to mention item 19 to 59.
19 to 59.
Yes, Your Worship, and item 135 to 139.
Just wait. 19 to
59, Your Worship, and 135 to 139.
Hmm.
This matter pertains to damage compensation petition.
Yes.
The matter pertains to arbitral award
Hmm,
is pending before the Honorable Delhi High Court,
hmm,
and the matter is going to be heard on 8 November 2023.
hmm.
So in the last occasion in the DP, your lordship has passed an order that this matter will be taken.
Let us first
on
read it.
19 to 59.
Yes, because
Yes.
135 to 139, there are certain instructions that my learned friend, the council appearing for the NHIDCL is supposed to bring. Or it may be taken up separately, my lord.
Okay. It's a analogous matter.
Yes, your lordship.
19 to 59 is an analogous matter, lordship.
Then
135 to 139,
it's different.
it's different. That is also analogous, but that's a different matter, lordship.
If it's analogous, how can it be?
135 to 139 is analogous,
Yes.
but it is not analogous with 19 to 59.
Is it? Is it? Is it so?
Your lordship,
Then we'll see, will 19 to 59 will adjourn, and we'll see 135 to what is this? It's for hearing.
this
We'll
is
see.
also pertains to damage compensation petition.
Maybe different place or different,
Not with the nation, but though I think but here, the difference in the facts of the case is 135 to 139 is that's particular stretch of the road as far as the NHIDCL affidavit is concerned. They are saying that that is only for maintenance, not for extension or widening of the road. And that is only a matter of statement. But as well, whether the DPR, the actual policy says that it is for maintenance and not for widening. That instruction, my learned friend, the counsel for NHIDCL is supposed to bring before his own court.
do you have that? Have you brought it? Yes, Lord. It's with you. We'll see, sir, we'll see. It's hearing is there, we'll see. If there is any difficulty, we'll accommodate you. 19 to 59. Mr.
After 8 November 22.
Mr. El Santam.
Yes, your lordship, 8 November 2023.
No, your name, Santam. LT.
Bongse Sangtam.
LT.
LT Sangtam.
LT Santam,
Additional HE.
addition, learned addition advocate general for the state. Submits that the related matter which is pending before the Delhi High Court,
Yes,
Honorable Delhi High Court, is likely to be taken up on 8 of
November.
8/11/2023. Therefore, praise for listing the matter after the matter is taken up at Delhi, Honorable Delhi High Court. Mr. Jesua, second learned counsel for the petitioner has no objection.
My lord.
You are also appearing in 19. Mr. Mojamil, learned counsel, appearing for respondent number. So present. Accordingly, list this matter. Appraise aloud, list this matter. After 11 as 8/11/2023.
Bless your lordship.
Yes.
Let me, sir. Lordship, I'd like to mention for item number 116.
116.
You know, so this matter was, in this case, the hearing is completed on last occasion.
Yes.
And you're allowed to file a written argument.
Hmm.
And you're allowed to file a written argument.
Yes. No, you just give it to it.
Okay,
Give it to the bench assistant.
okay, okay.
You also.
I already filed, Lordship. Yes, I already.
Okay. 116, huh? You don't have to call up, you just give it.
May I please, Lordship?
Yes,
Lordship, I'd like to mention item number 132.
132.
Lordship, I pray that this matter come up of 2 weeks.
132. Yes. On the prayer of so and so, learned counsel for the petitioner
For the respondent number 10,
for respondent number 10. List this matter after 2 weeks.
oblige your lordship.
Next, Lordship.
Yes.
Lordship, I'd like to mention item 67.
Hmm.
Lordship, let this matter come up for 3 weeks, Lordship.
On the prayer of so and so. No. 7 is analogous with
67.
6, 7, yes.
No, Lordship. 67.
67. Okay.
67.
Yes. On the prayer of Mr. Prosecutor, learned counsel for the petitioner.
Additional Lordship.
List this matter after 2 weeks.
2 weeks, Lordship.
3 weeks.
Lordship doesn't enjoy. Continue.
That is the problem. Interim order pass, adult shall continue.
Lordship. Lordship, I beg to mention item number 93. 93, Lordship.
93.
Lordship here, Lordship, on the last occasion, Lordship was directed to ascertain the address. Lordship, we are yet to ascertain the address. We are trying, but we cannot contact the respondent. So if Lordship may kindly give me two more weeks time, Lordship.
Yes, on the prayer of so and so, learned counsel for the petitioner, list this matter after 2 weeks.
Lordship, can you interim continue, Lordship? Interim, Lordship.
Interim order pass shall continue.
Maybe, Sir Lordship. I beg to mention item number 129.
129.
Yes, sir. I've taken the consent of the party. And I'm for respondent number 4, Your Lordship.
Okay.
Kindly allow 3 weeks time.
Mr. So and so, learned counsel for appearing for respondent number 4. Press for and granted 3 weeks time. List after 3 weeks. MS so and so, learned counsel for the petitioner present.
Like,
This Lordship.
Yes.
Lordship, I beg to mention item number 86 to 90. Here,
Huh?
yes, 86 to 90.
86.
Number 86 to 90. Lordship, here I am yet to file affidavit in reply. So
86 to
yes, 90.
90.
Yes,
Ah.
they allowed 3 weeks time to file reply.
On the prayer of Mr.
W. Macro, Lordship.
Learned counsel for the petitioner.
Yes, Lordship.
List this matter after 3 weeks so as to enable him to file affidavit in reply.
Yes, Lordship.
Yes.
Much obliged.
Please, Lordship. Lordship, I like to mention, item number 3 to 13, Lordship.
Item 3.
Yes, Lordship.
3.
Yes, Lordship. My senior, Mr. Gauhati is in very friendly, Your Lordship.
Item 3 is
130, Lordship.
Yes.
Yes, but my senior is in very friendly, Your Lordship, so he's unable to attend the program.
Bereavement.
Yes, Lordship.
What happened?
In connection with yesterday's accident, one of
Okay.
his relatives is included. So,
So I thought I'll dispose of this matter today.
yes, it is.
What to do? Bereavement to it's beyond anyone's control.
Next week. Let it be next week.
Can we try next week?
Yes, Lordship.
If not, I'll release from Pathat.
Next week, Your Lordship.
In fact, I have gone through the judgment also for dismissal. So better release from Pathat. That's what.
Lordship, an inquiry.
You said in one matter, you said it's just a statement on oath. Same thing. That's why you have to be very careful. It rebounds. Somewhere it catch you again. So let's try. Because we have spent, considerable time in this matter.
Lordship,
Let us try next week,
Lordship.
since I'll be there next week. We'll try on Tuesday. Mr. So-and-so, learned counsel appearing on behalf of Mr. Younger, but who appears for respondent number
5.
is learned CGC, appearing on behalf of respondent number 5 submits that Mr. Younger is in bereavement, for which he seeks sometime for listing the matter. Accordingly, list this matter. Thursday holiday.
Oh, yes.
You come to chamber. I'm ready. I have no other business. That's why holiday you come to chamber, we'll hear you in that chamber.
My lord, can we have it on Wednesday if it is possible? Because
Wednesday, no, Wednesday, DB.
after the DP, my lord.
Thursday. We'll try on Thursday. If you have difficulties, we'll release from partner.
Well, Friday, lord.
Friday, I'm planning to go back.
In fact, my lord, as far as the argument is concerned, it's almost as good as finished. So if we can just listen.
Thursday, we'll try on Thursday.
Lordship, can we make an attempt tomorrow?
Tomorrow is,
Meeting is from 1 only, so it will not take much time.
no, he's in bereavement, so he may not, he'll not be.
Today is the funeral, so hopefully tomorrow he'll be able to attend. So, again, my learned friend is having some difficulty.
Monday then,
Lordship, Monday and Tuesday, I'm likely to be at the principal bench.
and Tuesday. Oh, sorry. Friday will try on Friday. But unlikely. We'll list it for releasing from Farhat. Because next week too, you said not before Friday. You said Wednesday.
I was saying Wednesday, my lord, if it is possible.
Wednesday we don't know when there is a division bench. What to do?
Well, my lord, may kindly make an effort to try the matter on Friday because argument, the points of argument is.
No, I have to dictate the judgment also. Na? Friday I'm leaving.
My lord can keep it on CAB.
See what is there, CAB? There's nothing. The order will be 2-page only. Maybe your petition is very bulky. Initially, first blush, I was scared, so bulky. But when I looked into the entire page of your petition, there's nothing.
In fact, your lordship, but low points, as I've said from the beginning, low points are limited.
The judgment which you have relied, it hits you back. It's against you already. Okay, we'll try. I will try on Friday,
Friday, lord.
next Friday. Most probably for release from partners. Okay, list on Friday next. You just record the labor.
Lordship, I also like to mention item number 71, Your Lordship.
71.
Yes, Lordship. 2 weeks time may be granted, Lordship. To file RFA.
Yes, or the prayer of Jet Council for the petitioner. List
Respondent.
this,
Respondent.
respondent. List this matter after 3 weeks.
And
Your
your
Lordship, there is an interim.
Hmm?
There is an interim.
Okay. You are for petitioner.
Yes, Your Lordship.
Yes. So here's for petitioner. Interim order pass earlier shall continue. Yes.
and your Lordship, hearing item number 114, Your Lordship, and 131.
114. No, these two matter you cannot. 14 and 15.
114, Your Lordship.
Yes, 114 and 115. It's 2016 and 17 matter.
Yes, Lordship, but
Tomorrow. Can it be taken up tomorrow?
okay, Lordship, tomorrow.
Hmm?
Yes, Lordship.
In that case, younger Bati appearing.
Yes, Lordship.
In that case, we'll list the matter tomorrow. The other one also call this Joshua and this City Jami. Younger Bati is can appear tomorrow. So we'll take up your matter tomorrow. Tomorrow is Friday, we'll take up.
Lordship, but I have difficulty.
Huh? So in that case, we'll do that the bereavement so and so that will remain in view of the submissions of the learned counsel by the petitioner that he has, in view of his difficulty experienced by the learned counsel by the petitioner for his availability in the next 10 days. This letter is released from Patar. All right. Because you see, problem is, as per the roster, I'll not be coming here for another nearly 2 months. I've been stationed to Gauhati, principal seat. So if we cannot dispose of the matter, what to do?
Tomorrow, it's almost impossible for me, Lordship.
Okay. I'll decide later in the chamber. Then inform you. Order will be there. Either next Friday or tomorrow or whatever, or I'll have to release from the partner. I'll see. All right. I told I'll finish it tomorrow. It's okay. Either Friday or tomorrow or release from partner. We'll see. You accommodate this court also.
Yes, Lord.
Since I'm accommodating you, you accommodate this court also.
But tomorrow, Lordship, there is no possibility for me to be present, Lordship.
You are not here.
Lordship,
You are not here. Tomorrow you are not here.
I'm in Kohima, but I would be coming to court.
Why? Come to the court for 15 minutes.
Lordship, I have a
Make your
Jubilee program
submission
of my
and go.
village.
Huh?
My village Jubilee program, where I am the chairman, Lordship.
Have you invited all of us? You invite us, then we'll grant you a time tomorrow. You don't invite us, you want to enjoy yourself alone. It's okay for next Friday. We'll see.
My Lord. Lordship.
Let it be remain.
Can it be listed on Monday, Your Lordship?
Monday.
Monday?
Mr. Judge Kumlo, learned counsel appearing for Mr. Yangerbati, learned counsel for the respondent in one submits that Mr. Yangerbati, learned CGC is in bereavement. Therefore, it prays for listing the matter on 25/9/2023. Praise the Lord, list this matter on. Huh?
It is along one part.
Yes. 114 and 115, same. Together.
Your Lordship, item number 131, Your Lordship.
Yes,
Can it
same
be,
prayer.
after 2 weeks, Lordship, in this?
Yeah, for respondent,
Yes, Lordship.
after 2 weeks. Same,
Much obliged, Lordship.
Yeah, please, the Lordship.
Yes.
Lordship, I'd like to mention item 72, Lordship.
72.
Lordship.
Yes.
Lordship, I'm allowed week's time, Lordship.
On the prayer of Chancellor and council for the state council, huh?
Lordship,
Learned state council, this matter after 2 weeks.
Lordship. I have similar prayer for item 73, Lordship.
70,
73.
73.
Here also, Lordship, in the course of the day, I'll be filing my affidavit in opposition. Lordship.
This after 2 weeks.
Lordship. Lordship, I have similar prayer for item 18, Lordship.
You give the
2
number.
weeks.
You just give the number.
Lordship,
How many?
3 weeks time. Lordship.
3 weeks. Then, and then,
Lordship, item 80,
yes.
they've been seeking time for more than 6-7 months. It was last month and it needs emergency disposal, Lordship. Because this pertains to the petitioners where a post was advertised for regular appointment during this COVID time. Now on regular post. After the COVID was over, they have given us contract appointment, Lordship.
Yes.
So
No,
Lordship,
they may not like to fill up
Lordship,
on regular basis.
Lordship,
We cannot force them.
Lordship.
You are still okay.
yes, my
It's
lord.
okay, good. There's
Lordship.
millions of people who is jobless. At least you are in contract.
No.
But still then,
Yes,
Lordship, the advertisement specifically says that it was on the.
We'll see.
My lord will kindly appreciate that at that time, even the doctors, they resigned from service because they don't want to do. And we were the,
These people are doctors.
no, we were staff nurses,
Okay,
more serious than the
okay,
doctors, Lordship, in fact.
okay. You do your good service to the state. Continue to serve the state.
Of course,
We'll
Lordship,
consider.
that we will, but it has to be.
Why this has to be adjourned?
Lordship, I'm here to file my contract.
Okay, so without contract, it's not possible.
So Lordship,
But-
kindly give it as a last chance.
On the,
This
Miss-
matter was inherited by one of my colleagues, Lordship.
It's
and
okay.
I have been.
Mr. B.G. Momi, Learned Council Project. Learned State Council submits that he may be granted 2 weeks time to file a counter affidavit in opposition. Praise the Lord, list this matter after 2 weeks, so as to enable the Learned State Council to file the affidavit in opposition.
Interim may be continued.
MS so and so Learned Council petitioner present. Interim order passed earlier till continue.
Lordship.
Lordship, I have
Obliged.
item 81, Lordship. It's a bail application matter, Lordship. I'm yet to receive instruction, Lordship. A week's time may be granted, Lordship.
Lordship, this is the third instance, Lordship. This is the third instance where they.
Will dismiss, will hear and dismiss, NDPS,
Yes, Lordship.
Lordship,
there's nothing. Will dismiss. Will consider and dismiss, what do you say?
Lordship, a week's time may be given so that I will get an instruction.
It's a bail application, we have to, it has to be
Lordship,
heard
Lordship.
expeditiously,
Yes, Lordship. In fact, Lordship. but
after a week.
After,
Mr. B.G. Mobe, Learned Public Prosecutor, submits that he may be granted 2 weeks time to obtain the case diary.
yes, Lordship.
So as to obtain the case diary, Mr. So-and-so, Learned Council for the petition is present. Prayer of the Learned PP is allowed. This matter after 2 weeks.
A week's time.
After a week, so as to enable Mr. So-and-so to produce the case diary.
May I please, Your Lordship. May I be pleased to mention hearing item number 134,
134.
Your Lordship.
Yes,
Your Lordship, let this matter be subject to the outcome of the appeal. We have already filed an appeal to the similar matter. This matter relates to minimum scale of pay. Lordship, and we have already filed an SLP, Your Lordship. The SLP number, Your Lordship. So I will furnish now, Your Lordship. So Your Lordship, let this matter be subject to the outcome, Your Lordship.
there's a recent judgment considering all the earlier judgment by the Honorable Supreme Court. Unless there is a stay or there is a stay.
Your Lordship, SLP has been filed. It is to be listed, Your Lordship. So then, Your Lord, 3 weeks, Your Lordship, meantime we may.
You have no objection. No, in that case, after 2 weeks,
3 weeks, Your Lordship.
3 weeks. Indirectly,
Yes,
will not mention that.
okay, Your
because it's
Lordship. I
not
will pass the
permissible.
information.
High Court can take up unless there is an interim order.
Yes,
Just
sir.
because appeal and review has been filed, we just cannot
Oh, Your Lordship.
adjourn the matter. So we'll not record that
Your Lordship, Your Lord.
since he is not objecting.
Yes.
Ms. Lebika, Learned State Council, press for listing the matter after 3 weeks. 134, right?
Yes, Your Lordship, 1
Prayer not being opposed by the Learned Council by the petitioner, Mr. So-and-so. This matter after 3 weeks. We'll just adjourn it.
Yes, Your Lordship. Much obliged. Your Lordship, I also like to mention item number 94 to 110, Your Lordship. Your
94.
Lordship, 3 weeks may be granted for filing counter.
Yes, who is for petitioner?
Lordship, I'm for the petitioner.
94. No objection.
No.
MS So-and-so, on the prayer of Mr. MS So-and-so, MS Lebika, Learned State Council, list this matter after 3 weeks. So as to enable her to file the counter affidavit. Mr. So-and-so, Learned Council for the petitioner present.
Your Lordship, I also beg to mention item number 113 on behalf of Mao Inchin, Your Lordship.
No, no,
113.
113 already mentioned.
Oh, Your Lordship, 140, Your Lordship. 140.
Mentioned. Okay.
140, 140.
More Imsin, learned senior government advocate is in bereavement. He's in bereavement.
Is in bereavement, Your
Ah,
Lordship.
he's in bereavement. Therefore, press for listing the matter after 3 weeks.
Much obliged.
Yes,
Yes, my lord.
yes.
My lord, I would like to mention item number 14 to 17, my lord. My lord.
14 to
here-
17.
Yes, my lord. My lord, here I'm here to receive several copies of notice. So kindly listen that after 2 weeks.
Huh? What is it?
In this matter, I'm here to serve a copy to the respondent.
Is it
Yes,
Yes,
of the writ petition?
yes, my lord.
It's 2020.
Lordship, here, the writ petition was disposed of at the motion stage. And after that, the state filed an appeal,
Yes.
and the court has a question set aside the single judge judgment.
Extra copies.
And remanded back to the learned single
So
judge.
you have not received the extra
No,
copies?
no, Lordship, no.
Mr. So-and-so learned counsel for the petitioner submits that he may be, prays that he may be allowed to furnish the extra copies of the writ petition and the learned counsel for the petitioner. Prayers allowed this matter after 3 weeks.
After 3 weeks, Your Lordship.
The learned counsel for the petitioner shall furnish requisite extra copies to the learned additional advocate general, Mr. M.S.B. Sokri, during the course of the day or within 3 days.
Within 2 days.
Within 2 days.
Much.
Please, Your Lordship.
Yes.
Lordship, I beg to mention hearing item 124
124.
on behalf of the leading counsel, Mr. Siti Jamil.
Ah,
I pray that this matter be listed after 3 weeks.
on the prayer of MS so-and-so learned counsel to the petitioner, list this matter after 3 weeks.
That's good. Your Lordship, may I be pleased to mention item number 83 on behalf of Mo Inchin, Your Lordship. Your Lordship, your pleadings are completed. I'm informed that the pleadings are completed, so Your Lordship, let it come in the usual course.
83.
May I ask a question?
83.
83, Your Lordship.
83 already mentioned.
Mention.
Huh?
Oh, Your Lordship,
Okay, 83. 83.
83. Mention.
On the prayer of so-and-so learned counsel, but will list this matter after 3 weeks. 3 weeks.
Oh, Your Lordship. Your Lordship, similar prayer for item number 128 on behalf of Mo Inchin.
128, yes. I think this has also been mentioned.
Oh,
She just mentioned.
Your Lordship. My apology, Your Lordship.
How many matters do you want to mention?
May I please, Your Lordship, I beg to mention item number 130, 130.
130.
Yes, Your Lordship. My senior has some personal difficulties, so kindly listen
Huh?
letter. My senior has some personal difficulties.
What this personal difficulty? Huh?
Your Lordship,
It's a hearing matter.
yes, Your Lordship.
Okay.
Kindly list the matter after 3 weeks.
On the prayer of MS so-and-so learned counsel for the petitioner, list this matter after 3 weeks.
There's an interim, Your Lordship.
Interim order passed, earlier shall continue.
My please, Lordship.
Yes.
Lordship, I beg to mention item number 92 on behalf of Manas Das Gupta. Since he's an outstation lawyer, kindly fix the matter on 12th of October
90,
92.
92. Yes, on the prayer of so-and-so learned counsel for the learned counsel appearing on behalf of Mr.
Manas Das Gupta.
M. Das Gupta. List this matter after 3 weeks.
12th of October, Lordship.
Huh?
12.
12,
Yes, Lordship.
12 of October.
Much obliged.
Yes, Your Lordship. Your Lordship, I beg to mention item number 111. 111.
Yes,
Dear Your Lordship, we are appearing for respondent 5 and yet to file our affidavit, so
I may so and so learned counsel for the respondent number
5, Your
five.
Lordship.
Press for and granted 3 weeks time to file their affidavit in opposition. I may so and so learned counsel for the petitioner present, huh?
Lordship,
List after 3 weeks.
Please, Lordship.
Yes,
Lordship, I beg to mention hearing item number 121.
One-
My senior more than
121.
yes, ma'am.
Yes.
My lord, my senior has some personal difficulties to take up matters.
Ah,
My senior he has some personal difficulties, so let him may have come up after 1 week.
Mr. So and so learned counsel for the petitioner. Press for and granted 3 weeks time. And on the ground that his senior has some personal difficulty. This after 3 weeks.
My lord, similar prayer for item number 123.
1, 2, 3.
Yes, ma'am.
1, 2, 3, I think already mentioned. 1, 2, 3.
Yes.
Other one is which matter?
Ma'am,
Other matter is which item?
121.
121. Yes, 121, 120. Same.
Lordship, I beg to mention hearing item number 133 also. 133. 133.
Yes, same prayer.
No, Lordship, let the matter be passed over for the day. Let it come up tomorrow.
Tomorrow. This of 2021.
Yes, ma'am.
What is the matter?
Lordship, the petitioner is praying for compassionate appointment.
Huh?
Compassionate appointment. The petitioner's wife was serving in the Department of Railways.
CGSC is there. Who is the respondent?
Ma'am Nuksindila.
Huh?
Ma'am Nuksindila.
Have you informed him
My lord, yes.
on the prayer of so and so learned counsel for the petitioner? List this matter on. Tomorrow is 21st, 22nd. We'll see tomorrow.
Deeply apply.
Yes. Four 39.
Yes, Lordship.
Will issue not, will call for the CB. Do you need to issue notice?
Lordship, yes.
Yes.
Lordship.
Where respondent is there?
No, Lordship. Just,
Will issue, will not issue notice.
Lordship.
We are appearing.
Lordship.
Call for the CD.
I think charge sheet is filed, Lordship.
Okay.
Charge sheet.
Charge sheet has been filed.
Not yet, Lordship. Yeah, charge sheet not yet. It's still in investigation process.
Check up. Mr.
Lordship.
Learned counsel. I heard Mr. So and so learned counsel for the applicant. Also heard Mr. B.G. Mobile. Learned Kiangami, sorry, Kiangami, learned PP for the state. Next paragraph. We are filing this application under section 439 of CRPC 1972. The applicant prays for release of read with section 37 of NDPS Act. For praying for release of the accused. Which is name of the accused?
Robin Jimo, Lordship. Robin Jimo.
Release on bail of the accused Sri Robin Jimo in connection with special case number 42 of 2023 corresponding to not PS case number 0036 of 2023 under section 22 within bracket B of NDPS Act 1995. Call for the scanned copy of the CD. Case diary, huh? Case diary. List after 2 weeks. 2 weeks, all right?
Yes.
Or 1 week?
2 weeks.
2 weeks.
Please is on.
Yes.
This is a quashing petition.
Yes.
So, Chumokadima FIR notes.
Hmm.
If I may lay down the facts
Very
Yes.
initially, Manoj, very shortly.
Yes.
Manoj, the FIR is of 15th of April 2023.
Is it
FIR.
for quashing of FIR or something, the proceedings?
Washing of entire proceedings, Manoj, FIR and all consequential proceedings.
Okay.
Manoj, the facts of the
So
case
what
are
is the stage of the matter? The
the
case?
stage, Manoj, it's still being investigated, and a warrant of arrest has been issued. 4 warrants, 5 warrants of arrest had been issued in the July 2023, pursuant to which the petitioner had been arrested in Kolkata. So it's still being investigated. I'll shortly narrate the facts, Manoj. 15th of April 2023 is the FIR, Manoj. The allegation by respondent number 2, who is the controller of examinations of Global Open University in Dimapur, is that from December 2021 to June 2022, there was one individual, we'll call them A, Milords, for now. Milords will kindly consider A, defalcated the accounts of the university in conjugation, in conspiracy with B, C, D, and E, 4 other individuals. This is the allegation in the FIR. Milords will note that the petitioner is not named in the FIR. There is not even an implication, direct or indirect, nothing. The FIR is lodged, investigation begins. On 24th of July this year, 24th of July 2023, the IO files a request for issuance of arrest warrants and search warrants. There is where the petitioner's name is included for the first time. The prayer there, because the entire letter, it says that prior to the transaction, which is alleged in the FIR, in 2021, in September 2021, that is before December, September 2021, the petitioner had entered into some other transaction, completely separate, has nothing to do with the accused in the FIR or his co-accused, to try and cheat the university, allegedly. Then again, the arrest request says that in August 2022, August last year, the petitioner had issued a check to the university for a donation, which bounced. Therefore, and this is a matter of record, Milords, thereafter, a notice under 138 had been sent to the petitioner. This is suppressed. This is suppressed by the respondent number 2 before the police, but nothing had happened after that. On the basis of that letter for arrest warrant to be issued, on 26th, Milords, 26th of July, the learned magistrate in Dimapur allows the request without application of judicial mind to the fact that the petitioner's role, as per the investigating officer, has nothing to do with the FIR, has nothing to do with any of the remote allegations in the FIR. The petitioner, Milords, had a stent inserted into her bile duct in July. In that state, she was pulled out from her house. She was produced before the learned magistrate in Alipur in Calcutta, who thankfully saw that there is nothing in the case and granted transit bail to the petitioner, saying that on 27th of this month, she is to appear before the learned magistrate in Dimapur for bail confirmation. My humble submission before your lordship is this. This is an absolutely frivolous case, which has been vexatiously issued, vexatiously initiated as an afterthought by the respondent number 2, not through an FIR. But the IO thought that when he received this new information regarding the petitioner, he should consider it as a 161 statement in view of the T.T. Antony principle instead of registering a second FIR. Now, Milords, I'll take lordship to the FIR at page 52. Page 52 is the FIR, Milords. Page 54, the narration begins. Page 54, Milords.
Just wait, just wait.
Yes.
Yes. Where it
Milords,
is?
page 54. Milords.
Hmm.
This is the written intimation based on which the FIR has been lodged. This written intimation at page 54, Milords, is of 28th of January 2023. It has been written by the respondent number 2 before your lordship. Lordship will see at the top, complaint against Mr. Timir Kanti Majumdar. Timir Kanti Majumdar is the sole named accused, Milords, in this complaint. Now the allegation, my lords, I have only 4 points, my lords, which will summarize the allegations in this entire complaint letter. Number one, he says at the bottom of page 54, my lords will see in the last paragraph, 6 lakhs were given to him in December 2021. My lords will see at the bottom of page 54. Rupees 6 lakh was transferred to an account by Mr. Tarun Naskar, an associate of Timir Kanti Majumdar. This is the first allegation of cheating.
Where it is?
Page 54, bottom minutes. In January, Mr. Timir Kanti Majumdar proposed us to invest rupees 6 lakh, which would be given, which would give a donation of rupees 1 crore. Page 54 minutes.
What does it mean?
Now, my lords, this is an allegation against Mr. Timir Kanti Majumdar.
No, but then what did you say?
Yes, my lords. The allegation is that he sought for 6
6
lakhs,
lakhs.
saying that I'll give you a donation. I'll get you a donation. So his fees, he
You,
said,
you
6
give me 6 lakhs, I'll give you a
I'll
donation.
get you a donation from someone. That was what he promised. Now, this is number 1 minutes. Number 2 minutes will kindly see directly at page 55, bottom minutes, page 55 middle, there is a paragraph being a university. As we'll see, and this is some relevance, minutes, because being a university, we are not a trust society, so and so. Hence, 80G 12A Niti Aayog approval is not applicable to the university. Because this is an admission in the FIR that the university actually cannot take donations. But without 80G so and so, such donations are not possible. Being deficient of these documents, we agreed to get the donation through Radhakrishna Mission, West Bengal. The individual, Mr. Timir Kanti Majumdar Millets,
We agreed or we agreed to get the donation?
Millets, that is a typological error, typographic error. I believe, I don't know, Millets, this is, it says greed, Millets, probably poetic justice. But as far as this paragraph is concerned, it is an admission by the respondent number 2 in his FIR that we actually cannot accept donations. But because the treasurer of Radhakrishna Mission in West Bengal is saying that he can get us donations, we agree. Now, Millets, number 3. Millets will kindly come to the bottom of page 55, the last paragraph, based on the assurance. Millets will see, based on the assurance from Timir Kanti Majumdar, the donation is legal. Messrs. Zakai and Company invested rupees 1 crore 50 lakhs by the way of 4 demand drafts. Millets will kindly see, this is not the university. This is some random, some stranger, independent, some autonomous body which has made investments. But be that as it may, Millets, even if we assume that this payment is being made by respondent number 2 or at the behest of the university, Millets will kindly note the amounts which are being paid and the names, Millets. My name is nowhere there, Millets. These are different people. The first A is to Radhakrishna Mission, B is to Mehti Fish Traders, Sasa Bindu Mehti is in custody presently, Millets. C, Millets, is to Biswajit Sardar, and D is to one Bholanath Majumdar. These are transactions in 4 tranches, which the FIR alleges is at the behest of Mr. Timir Kanti Majumdar. Now, Millets will kindly come to page 56, which is the last page of the complaint. Millets will kindly come to the middle. Again, a donor company. Millets will kindly see at the middle. Again, a donor company was proposed to perform on 8th April 2022, for which a booking amount of rupees 12 lakh was requested by Timir Kanti Majumdar, which he did not have. On his assurance that the donation work would be executed on 8th April, and he required 12 lakhs for 1 day only, and Mr. Timir Kanti Majumdar would return the 12 lakhs the next day. Our director came forward and transferred 12 lakhs to Timir Kanti from his personal account. Millets will kindly note this for now, Millets, because this is very important. Because throughout the documentation I'll show, the respondent number 2 keeps on saying that money is being sent from the personal account of this director, late Dr. Ao of the Global Open University, through so and so as an online account. Now, Millets will kindly come to the end of the FIR, which was the point that I was trying to get to initially, Millets. Since 7th of June 2022, Millets will kindly see the date. 2022, I have been asking Mr. Timir Kanti Majumdar for return of rupees 1 crore 50 lakhs and rupees 12 lakhs, which we had given to him, but in vain. Every day he commits to return back the payment given by us, but fails to return it. Humbly requested to register a case of fraud, cheating, and so in the name of donation work against Mr. Timir Kanti Majumdar, Treasurer Radhakrishna. Now, this is the complaint letter, Millets, which forms the bedrock of the FIR in the instant case. During the course of the investigation, Millets, the respondent number 2 comes to the police office, comes to the IO, and he starts leveling allegations against the petitioner regarding certain transactions which have nothing to do with this. This I'll show Milords from the warrant request which was presented by the IO, which is at Annexure H, page 64. Milords. This request, Milords, is from page 64 to page 68. Milords will kindly note, my submission, my humble submission is that page 67 and 68 of this warrant request, that is part B of the request, and part A of the request is 64 to page 66. They have nothing to do with each other. And I'll show Milords why. Page 64, Milords, this entire...
It's okay. What has to be done today?
Yes, Milords. My humble submission is...
Will issue notice?
Milords, my humble submission is, Milords, that insofar as the petitioner is concerned, there is absolutely no case which can be made out against it. Because insofar as a common FIR is concerned, or a common investigation is concerned, that can only be done when there are four things. Milords. When there is a proximity of time in offences, when there is a unity of place, when there is a commonality in action, the continuity in action, or a commonality of purpose. There is nothing, there is none of these things between...
Did you appear? Did you appear here?
No, not here, Milords. Here, Milords, the impossibility is this, Milords, that I can't travel. Milords will kindly see Annexure B at page 36, Milords. I have been operated upon only recently. I have a stent in my bile duct, Milords. And now, Milords, the stage of the investigation is such that it's a roving and fishing inquiry, Milords. There cannot be any investigation.
We'll see that. We'll see that. We'll call for the records, but you appear.
Milords, if
we'll give you interim protection, provided you appear.
Milords,
or else we'll just issue notice. No,
Milords, if I may appear through BC, Milords will kindly see there is a possible, there is a certified copy of the order sheet, Milords, of the magistrate. On the last date, on 6th of September, the person who has been arrested, Sasabindu Mehti, he has appeared through BC, Milords, before the learned court. Milords, traveling for me, Milords will kindly see my medical certificate at page 36. It is impossible, Milords. I have to be in bed rest in Calcutta. She will have counsel, Milords, there is no difficulty in appearing at all. But Milords, only two things, that no other coercive action may be taken. And secondly, Milords, she may appear through BC, if that may be provided.
What does it mean?
Milords, this order of 6th of September 2023,
yes,
it shows that Sasabindu Mehti, who has been arrested in the matter, he's in custody. He was produced through video conferencing, Milords, before the learned court below. So my humble request is, Milords, that I have there are no qualms regarding appearance or regarding even participation in the investigation, Milords. However, Milords will kindly see that there is a provision to appear through BC before the learned court below. And Milords, I cannot appear because I'm physically incapacitated at this moment, Milords.
Within 20 days, by the time you'll be all right.
Milords, no. Milords will kindly see, Milords will please see page 36 for a moment, nothing else, one page in the petition. My stent removal is in 3 months.
See, this accused was through BC from the police station?
No, it's from JC, from judicial custody. He's in judicial custody now.
Its investigation is going on.
Yes, yes. Investigation is still going on. Milords will only see page 36, Milords.
Yes.
Page 36. This is the letter from Rabindranath Tagore Institute, Milords, where she had her surgery. The second paragraph, she has been advised stent removal within 3 months as told to her. This is on 12th of September. Milords, till then, Milords, if I may be given interim protection, I have no qualms regarding appearing before the court here, Milords. It's only that for 3 months I cannot travel, Milords. I need domiciliary treatment, Milords. It is there. It is provided in this letter itself. And Milords, to show that this doctor, in fact, is a genuine doctor, Milords, I have also annexed another document. Milords will see at page 34. The hospital itself has said that Dr. Sandeep Pal, he is to look after the petitioner while she is at home.
What does it mean? Treatment still removal?
Yes.
What is this removal of stent?
Yes. So, Milords, what had happened?
Is it so serious as surgery?
Yes, yes, Milords. I'll show Milords the surgery.
We don't know.
A at page 33, Milords. So what had happened, Milords, is that she had a pancreatic stone. When she had a pancreatic stone, initially she had a surgery, and they found that the bile duct, which comes from the pancreas to the liver, it was riddled with stones. So they had to open the bile duct, and now for her bile duct to function, a stent has been put there. Milords will see at page 33. This is the discharge certificate of 29th of July, 2023. This is 4 days before she was arrested from her house, Milords. The final diagnosis, Milords will see, these are all issues that she was suffering from at that point of time. And the stent that was put, the ERCP plus stent, that is still there in her body, Millards. And that's why she cannot travel, Millards. Because if she moves, that stent will also move and Millards, she'll suffer irreparably.
You have been discharged on 29 July.
Yes, 29 July, I was discharged, Millards. And 29 July, the issue arose, Millards, because after 29 July, she was dragged out from her bed at home on 3rd of August, pursuant to the order of the learned court below here. The arrest warrant that was issued here. She was dragged to Alipur, and there she had to pay transit bail. After that, Millards, she has been at bed in bed rest again, and she has to be till her stent is removed, Millards.
That is the problem. You have been given the transit bail and then you are not, you have not appeared.
No, Millards. I have no qualms with appearing, Millards. It's only an extension that I humbly request for, because, Millards, this investigation, Millards, it's absolutely malified. There is no way that such an investigation can happen.
Can't say now.
Millards, I'll demonstrate, Millards. That's why I'm showing-
At this stage, we cannot.
Millards, I'll show the warrant request. Millards will kindly see at page 67. Only one page, Millards. Millards will kindly see one page, page 67. If this is an investigation actually into the petitioner, and she's actually in conspiracy with Timirkanti Majumdar and his other associates, this table at page 67, Millards, it completely shows, it's an elaborate table which shows all transactions among all accused persons. Now, Millards will see whose name is actually
looking at the papers, documents,
Yes.
it's an investigation.
Yes,
How do we jump in?
No, Millards, this investigation emanates from one FIR. In that FIR, the transactions which are alleged about or averred about, in that I have nothing to do. And which is why, Millards, I'll only show one judgment. One judgment, 2013 6 SCC, Millards, Anju Chaudhary. Millards will see the Supreme Court's dictum is very clear that when can there be a common investigation? There are 4 things which have to be looked into. Millards will kindly see.
Are you praying not to investigate the matter?
Yes, Millards. In relation to me, I'm praying for a quashing of the FIR, Millards.
Washing of the FIR is something different, but
Yes.
you just cannot stop the investigation.
No, only qua me, Millards. Not Millards will kindly see my prayer. I'm not seeking that the entire investigation be stopped. Absolutely not, Millards. I'm only saying that qua me, there cannot be an investigation under this FIR, because Millards will kindly see what the judgment says, that if there is an FIR which says that there is a transaction between Timirkanti Majumdar and 5 other associates, and then later on, the complainant comes and says that Angaj Gautam has committed something in commonality with these people. Then what are the considerations which has to bear with an honorable court? Millards will kindly see in this judgment, paragraph 43. Paragraph 43 at page 414. Millards. Because I'll only read 3 paragraphs, 43 partly I'll read, Millards. It is true, paragraph 43, Millards. It is true that law recognizes common trial or a common FIR being registered for one series of acts so connected together as to form the same transaction as contemplated under section 220 of the code. Now, Millards will kindly come to para 44.
No, you read further.
I'll read further.
Read further.
Yes, I'll read the entire thing. There cannot be any straitjacket formula, but this question has to be answered on the facts of each case.
Yes.
Yes, Millards. Now, this is elaborated in the next paragraph.
Trying to avoid this. This is most crucial.
No, absolutely. Millards. I'm sorry. I'm not trying to do that at all, Millards. Millards will kindly say, I'll read the entire 3 paragraphs. This court and so held that the expression
You
same
should
transaction.
remember, this court is very meticulous.
Yes, absolutely. I'm sorry, Millards. I wasn't trying to mislead the court at all, Millards. And I apologize. This court and so held that the expression same transaction from its very nature is incapable of exact definition. It is intended to be interpreted. It is not intended to be interpreted in any artificial or technical sense. Common sense in the ordinary use of language must decide whether or not in the very facts of the case, it can be held to be one transaction. 44. Now, Millards, this is important. It is not possible to enunciate any formula of universal application for the purpose of determining whether 2 or more acts constitute the same transaction. Such things are to be gathered from the circumstances of a given case, indicating proximity of time, unity or proximity of place, continuity of action, commonality of purpose or design. Where 2 incidents are of different times, with involvement of different persons, there is no commonality, and the purpose thereof different, and they emerge from different circumstances. It will not be possible for the court to take a view that they form part of the same transaction, and therefore there could be a common FIR or subsequent FIR could not be permitted to be registered, or there should be a common trial. Similarly, para 45. Similarly, for several offences to be part of the same transaction, the test which has to be applied is whether they are so related to one another in point of purpose or of cause and effect, or as principal and subsidiary, so as to result in one continuous action. Thus, where there is a commonality of purpose or design, where there is a continuity of action, then all these persons involved can be accused of the same or different offences committed in the course of the same transaction. This investigation, my lords, is directly in the teeth of this judgment for one, and I can show from one page only, my lords, page 68. It is the IO's admission that I had nothing to do with the transactions of the other accused person. That he has made point-wise descriptions of the involvement of each of the persons in the transactions. My involvement has nothing to do with Timir Kanti Majumdar and the rest of his associates. My allegation is that earlier in September 2021, I had indulged in one alleged transaction of 22 lakhs, which has nothing to do with Timir Kanti Majumdar. And then later on, in August 2022, I had issued a check of 16 lakhs to the university, nothing to do with Timir Kanti Majumdar, which bounced. And they sent me a check bounce notice, which does not mention anything else, that I have colluded with somebody else. There is no commonality in the transactions.
Let notice going.
Well, considering her lady, she's a lady, petitioner,
Yes. 63-year-old.
her ailment and age will allow her to appear through BC virtual, all right? Within 10 days, all right? And if thereafter, we'll see. Warrant of arrest.
Warrant has been executed because I was
It
arrested. I
has
got
been
considered.
executed.
Yes.
Okay. In the meantime, within 10 days, we'll allow her to appear through BC. All right. Pending production of case. It will be case diary or North Court records.
No,
Case diary.
Case diary.
Case diary. That much. Nothing else today.
If the rest of the GR case may be kept in abeyance in relation to me, I'll appear.
No, today, if we fast, if you stay the proceedings, it amounts to staying the investigation. We'll see on next day. We'll keep it open. We'll not reject your interim prayer. Next day, on the basis of the records, we'll see.
Yes.
All right.
Yes.
Heard Mr.
A Gautam.
Huh?
A Gautam.
So and so learned counsel for the petition, and also heard MS Mere.
Yes.
Mere learned public prosecutor for the state. Next, by filing this application under section 482 CRPC 1973, the petitioners has prayed for quashing of the investigation as well as the consequential proceedings in connection with the CMDPS case number 28 of 2023. Corresponding to GR case number 276 of 2022. And section 417, 418, and 420 of IPC. Pending on before the Judicial Magistrate First Class Dimapur. And also non-bailable warrant of arrest.
Yes.
NBW. And also issuance of non-bailable warrant of arrest against the petitioner by dated 26/7/2023. Issue notice returnable within 4 weeks. Call for the case diary.
Yes,
Still copy of the case diary. Expedite. The learned counsel for the respondent, the petitioner shall take a steps for issuance of notice. Issuance of service of notice for service of notice upon the respondent number 2. Whereas for registered post with AD within 2 days. Having considered the submission of the learned counsel to the parties. And the materials annexed to the petitions. Petition. Calculate the fact that the petitioner is a lady of about 62 years of age, having multiple, having serious ailments, which she has undergone surgery, for which she has undergone surgery. In the interim, the petitioners shall be allowed to appear before the investigating officer.
The court will.
So,
The court will.
huh?
For the learned court will. Because I have a bail confirmation hearing before the learned magistrate. On
What?
Yes.
Investigation is going on.
Very well. Very well.
Are you
Very well.
investigating officer as well as before the learned court? Learned Court of Judicial Magistrate First Class
MFC Dimapur.
through BC within 10 days.
Let's kindly fix a date because we know it's 27th of this month was fixed by the learned court in Alipur. A short extension.
Appearance.
Yes. For bail confirmation.
When?
Let's second week of October, that's anytime. From between 9th and 13th.
You just
You convenient that you just.
That's any Monday, any Monday or Friday. 9th of October.
9th. Will it be all right?
Yes, sir.
9, 10, 20. Fixing this matter or BC?
No,
To
that's
appear-
for the bail confirmation.
Huh?
For the bail confirmation before the learned magistrate.
No, in that case, we'll fix 20 this week, next week, 29.
For this matter.
Yes, no. For your appearance to BC.
Before this.
For the
On that
magistrate.
day, you may pray for a confirmation or whatever before the court.
Because
Because I said before Iowa as well as before the learned magistrate. So 29, on 29, huh? List this matter after 3 weeks. 3 weeks,
the fixed date person, but I am very requesting.
9th of October. Give it back. Item number 18.
My lordship,
Yes.
lordship, the leading counsel, lordship is in the out of station for medical treatment, lordship, the medical note of 2 weeks. Lordship, the matter will be posted for hearing, lordship.
Okay, elsewhere has been whether all the parties.
Lordship, the respondents are represented by Mr. Wan Chetri, but his name is not reflected, lordship. So lordship may kindly post for hearing, lordship.
As per office note dated 3008/2023. Elsewhere has been received. Mr. Mr. Third, Mr. Posikabote, learned counsel for the petition. Appellant. Learned counsel for the appellant, list this matter. For hearing after 3 weeks. 3 weeks, not today. That's right.
Item number 60 and 61.
What is this?
Let me see, Lordship.
Yes. What is this?
This implementation pertains to regularization of service, Your Lordship. And I have served for 32 years. So this is currently cover. Yes, Your Lordship.
Have you gone through? Judgment of the division bench.
No, Your Lordship, it's different.
It goes against you. In view of this, your writ petition will be dismissed. You are praying for
I'm praying for regularization. of service.
regularization.
I have served for 32 years, Your Lordship, and this is squarely covered by the office.
Have you gone through this judgment of the division bench?
Oh,
This matter has been listed after the disposal of this writ April 27 of 2022,
no, Your Lordship, I'm not aware.
where this on the basis of the Nichibi Achumi decided by the Honorable
No,
Supreme
Your
Court.
Lordship, that is not relevant in this issue, Your Lordship.
Ah,
That Nishibi is has served only for 12 years, if I'm not mistaken. That is not covered by the office memorandum of 2015, Your Lordship. That is totally irrelevant, Your Lordship.
huh?
That is irrelevant.
He served for 12 years,
And in my case, I have served for 32 years.
32 years.
Yes.
The requirement is what?
There's in scheme, Your Lordship. It's in page 28. Your Lordship.
You have already retired.
Yes, Your Lordship.
Hmm?
Yes.
You are
Okay.
still in job.
No, I've retired already, Your Lordship.
Huh? You have already retired.
Yes, Your Lordship. I have served for 32 years and released from service.
Madam, what do you say?
The petitioner.
Do you say, are you saying that this WA 27 covered the case of the petitioner?
The facts here is a little different.
Ah,
The petitioner is enjoying the scale, he has been upgraded to scale pay and his case is under consideration. I have, just this morning only, I have received instruction that his case is under consideration for regularization, so.
so will you have it
That
for
takes-
some time?
Yes,
If they are under consideration, if your case is under consideration, why unnecessary we should pass an order? All right,
or otherwise the matter.
but
can
you
be
look,
disposed of
this is
placing the
different.
Letter on record, Your Lordship.
Let me see. In that case, will you wait for some time? Is not it? Why burden with all these orders? And according to you, this doesn't cover.
Facts is a little different.
No, facts or law,
Yeah,
whatever.
Yes, Your Lordship.
It doesn't cover.
Your Lordship.
Huh?
It doesn't cover, Your Lordship.
Okay,
It comes within the
fair enough, fair
purview
enough.
of the scheme.
This is
In
220,
respect of
228. Writ petition,
repetition 202, Your Lordship.
what is the direction in writ petition 228?
You were granted scale of pay, Your Lordship.
Hmm.
228 is at page, it's annexed to the repetition, Your Lordship.
This 203, writ
Regarding
petition 203,
regarding 203,
the petition case will be considered as per
petitioner-
the administrative
yes.
approval dated to, what does it, administrative approval is what?
administrative approval is annexed to the letter, Your Lordship.
Okay,
It's at page 3, your lordship. To grant scale of pay to the petitioner provided the budgetary provisions are available. So once they are upgraded, they will come within the purview of the scheme for regularization.
so,
Yes,
so they can be regularized.
lordship,
They can be regularized.
they can be considered as per the scheme, your lordship.
Okay,
Yes, yes, your lordship.
this office memorandum,
Yes, your
office
lordship.
order.
Office order, yes, your lordship.
So you work
So-
for some time.
Yes,
I
it's a
think your
matter of
case is-
time, your lordship.
Huh?
Your lordship can dispose of basing on this order, given a specific time.
No, there can't be a time bond, your lordship, because we don't know how
What-
long it
what-
will take. Yes,
We'll expect that they'll,
of course, we will
Eh.
expedite, yes, your lordship.
expeditiously, we expect that they'll do it. But we'd wait for
As
some
early as
time, or
possible,
next
yes,
day,
your lordship.
we'll give them 3 weeks time.
3 weeks will be too short, your lordship. 3 weeks will be too short.
See, even if we get them, ask them to, if we dispose of the matter, with direction to decide the matter, whatever, if they don't unnecessarily, you will have to come for contempt and all those things.
Yes, that's why, your
So
lordship.
ultimately, you want your regularization. Is not it?
Yes.
For the purpose of pensionary benefit,
Yes,
that's all.
yes, for that.
So if
purpose
they are
only.
considering the matter, we'll wait for that sometime. We'll list this matter after 3 weeks,
4 weeks, your lordship.
4 weeks. On that day, if nothing comes, I mean, nothing positive comes forward, we'll decide the matter. All right? Because you are no longer in the service, you have all been retired.
Yes, yes.
It's a matter of time only.
Yes,
I mean, government is gracious enough. But I thought I'll dismiss your writ petition because of this judgment. So if learned council is fairly submitting that it's not covered, then
That's irrelevant, your lordship.
heard MS so and so learned council for the petitioners. Both the cases, huh? And also heard MS S. Mere,
yes, your lordship.
learned state council for state respondents. As of now, will not say that your submission that is not covered or something. I will not say. It may have some bearing on you also. We'll just record this and we'll.
Yes, your lordship.
After hearing the matter for some time, the after arguing the matter for some time, the MS State Council produced a communication dated 20th September 2023. Issued by the Chief Engineer PHE Sanitation and WSS of Nagaland, Kohima, informing her that the case of the petitioner in writ petition number 202 of 2021 is under process for regularization as per the OM that's 17/3/2025, 2015, sorry. And such process of regulation may take some time. Insofar as in case of the petition for in writ petition number 203 of 2021, sorry. The case of the petition will be considered as per the administrative approval dated 28/1/2024. In view of the above matter distance adjourned for 4 weeks so as to enable the state respondents to expedite so as to enable the state authorities, state respondents to complete the process as complete the process expeditiously. Expeditiously. List after 4 weeks.
I don't know.
What is this? Sir,
This matter was on the last occasion. Now this contempt petition is also related to the written petition, so a direction was given to use the contempt petition together with the phrase. So that now come after the accusation phrase. So the writing of the petition for where?
Mr. Topok Foreign London Consultancy petition and also Mr. B. Jimobi, London District Council. On the prayer of on the submission of the London Council for the parties, list this matter for hearing and its usual course.
I don't know.
68 to 70. What is this?
Lordship, it's a- the impugn is against the Lok Ayutta. Lordship may kindly refer the last order, Lordship. Says that the last opportunity has been given to the Lok Ayutta to appear before this reports on the court. Today, Lordship, Present Lordship.
What to do?
Lordship, the instruction of my senior is that Lordship, usually in Lok Ayutta matters, Mr. T.V. Jamir is to appear. Lordship, he wanted to see the files, so we have given the file to him. But since he is not keeping well, he did not come to the Lordship. Lordship may kindly miss the matter up to a week, Lordship. But he is yet to decide if he will be taking up for the Lok Ayutta or not.
Oh,
Mr. T.B. Jamir,
TB Jamil.
Lordship, is for the Lok Ayutta. But not a standing council, but
In that case, we'll fix for hearing. We'll proceed.
Lordship,
In the
Lordship,
meantime, whatever they.
Lordship.
Mr. Fosika Patel, London Council for the petitioner. Heard Mr. Fosika Patel, London Council for the petitioner. Also heard MS. Merit London District Council. Admit. Mr. This for hearing, it's his usual course. There's no urgency.
Interim Lordship.
There's no urgency.
There's urgent Lordship, but there's an interim Lordship. Interim maybe
Interim order pass, area said,
continued Lordship. Right, my lord.
Yes, sir. What is this?
Lordship, since leading counsel is on leg on court number 1, Lordship, if this matter can come up after the listed matter.
What is the matter, sir?
Your Lordship, the matter is regarding the state respondent, they were to construct SDO civil office at Sanish Wakhar. So accordingly, they approached me for parking my private land. So I agreed after their request. But
GA rest house.
yes, Your Lordship. So there was verbally agreed between the parties there. I am ready to part my plot of land.
So what is your prayer?
Prayer, Your Lordship, as per our verbal agreement, that the work execution for the construction of GRS house would be subject to me. And secondly, all grade 4 post would be provided to my family members. And thirdly, monthly rent of 35,000 would be given to me for parting my plot of land. No doubt, your lordship, there was no written agreement.
You go to civil court. There's no written agreement, verbal agreement.
So your lordship,
Go to civil court, sir.
your lordship, in that case, since they have already constructed this GRS house and it's functioning now,
You take it back,
your lordship.
go to civil court.
What about then Article 300A, your lordship? That is my private property.
Huh? That's why you take it back. 300A.
Yes, your lordship.
Therefore, it's your property. Take it back. Go to civil court for damage or compensation.
No, your lordship, as per the agreement, they were to.
This sort of cannot be the comes under the realm of public law. It's a purely private law.
Your lordship, as I said, since Article 300A is part of Constitution, so I have filed my.
Who says it's not a part of Constitution?
So your lordship,
Huh?
under this.
That's why you take it back. You have
Yes,
been, you have done it. Has they taken away your land?
Yes, your lordship, and now the building has been fully constructed and it's functioning now.
How can without there being any agreement or
That
the
is what your
contract, how you have constructed the house?
That
You
is
take
what
it back, it's your land.
My,
If
my,
anything is there, you go to civil court.
my fundamental rights has been violated, your lordship. And
You
this-
don't have a fundamental right to do business with the government.
They were the one who approached me, your lordship.
Where is this?
Your lordship.
Where is the contract? Where is the contract agreement?
No, there is no contract.
Then, if there is no contract, even if it's their contract agreement, it's a pure breach of contract.
Yes, your lordship, then in this.
So if in case of breach of contract, what the appropriate remedy lies?
Yes, as I said, your lordship, my fundamental rights has been violated, so.
You don't have a fundamental, as I said too, you don't have a fundamental right to do business with the government.
No, I'm saying, your lordship, this court is directing me to go in other platforms for seeking relief.
Huh?
That is what I'm saying, your lordship, this court has jurisdiction to entertain this petition, your lordship.
Why?
That is what I'm saying.
Why?
Regarding fundamental rights.
First requirement, there is no violation of your fundamental rights.
Your lordship, that is definitely, because
Much less the constitutional right.
right to property, it's a part of constitutional rights.
Nobody disputing that, sir.
As well as human rights, it amounts to human rights. So this court is saying-
Suppose you have constructed a house on your own land on the alleged verbal assurance of the government. Is it a violation of fundamental rights?
Definitely, your lordship, since there was verbally agreed terms and conditions, there were verbally agreed terms and conditions. Then now
Where is the agreement?
that is what, your lordship, I am saying, it verbally it was agreed between the parties.
How do
I'm saying myself that, your lordship.
How do we believe?
Your lordship, if that is not the condition, then I would like to draw the attention of the court to.
What do you want?
Your lordship, I'm pressing for what was the agreed between the parties.
How do you come to a conclusion? First, we have to come to a conclusion that there is an agreement between you and the government.
Yes. So your lordship.
From where? From where?
No, your lordship, if it was not so, I would like to draw the attention of the court, page 23, your lordship.
Ah.
Annex 5, page 23.
Yes. Because these are the things, since you don't have the agreement as such, even if
No,
you have,
your lordship,
had you had some agreement, you
Your
could have
lordship,
understood.
I will
It
just
needs
want
needs an evidence. So far as your statement is concerned, it needs this evidence has to be led.
Yes, lordship.
Where it is,
Page 23, your lordship.
Ah.
Annex 5.
Hmm.
This was written by the defendant, respondent number 3 to
Hmm.
the petitioner.
Hmm.
Here, at first paragraph, last line, your lordship, the petitioner, respondent number 3 clearly says me that payment will be made to you as and when the fund is released by the government.
It is therefore requested to withdraw the application and payment will be made to you as well the fund is released by the government. So your lordship, I am saying if it was not agreed, then why this respondent number 3 would address me this particular letter?
So on the basis of you initiate a civil suit
Your lordship, as I said,
or money suit?
this court is saying that this court is not having jurisdiction to entertain this petition. This is what I am saying, your lordship. Even though if there are
Yes, because some people, some officer writes a letter to some officer, it doesn't establish your right.
Yes, your lordship, this respondent number 3 is
So on your statement, sir, it requires evidence. So file a money suit or whatever.
your lordship, in that case, since today I don't have that citations with me, there are certain citations by the Honorable Supreme Court where it has said that even if there are other remedy available, if there is any violation of the fund, there are 3 fundamental basic principles where the High Court can also entertain. As of now, I was not prepared for that this court will not entertain my petition. So your lordship, short time may be given. I will cite that rulings to the Honorable Court for entertaining my petition, your lordship. Because there are 3 basic fundamental rights, even though if there is other remedy available.
Sir, these are all settled laws. And this court is conscious of all this. At least these settled laws, this court is conscious of that.
No, your lordship, since I don't have that citations as of now with me, it is not.
No, you don't have to cite.
No, your lordship.
You don't have to cite.
Number 1.
I'm conscious of all those laws settled by the Supreme Court. That is why I'm trying to tell you.
So your lordship, that is not in my mind. If your lordship would be kind enough to remind me those 3 principles, because I can argue on that, your lordship. As of now, it is not in my mind. But of course, it was one of these fundamental rights when there is violation of.
On the prayer, what's your name?
P. Suren.
Huh?
P. Suren. P. Suren.
Who is appearing for the state?
Enangami for the state.
So he's busy there.
Lordship.
We'll take after some time. You
Today-
find
today,
out.
lordship.
Yes, you find out those laws.
I
If
don't know
you-
whether I'll be getting, anyway, your lordship, I will try to get those rulings.
I think internet facilities is there.
Okay.
Do you use the Google or SCC? Huh?
Okay, your lordship. Public.
You're Syrian.
Yes.
Okay.
Yes. I don't know what it is.
May I please, the lordship.
Yes.
Our lordship is gracious enough to list the matter today, lordship. On the last occasion, lordship was mentioning with regard to the criminal complaint petition that
Yes.
was filed before the lower court below,
Yes.
which was withdrawn, lordship. Lordship, to that I have an instruction, lordship. If I'm allowed to place that on.
Yes. Yes.
Lordship, this morning I received from instruction from the officer in charge is police station, lordship.
Which one?
This one,
This one,
yes, lordship.
black or white?
White,
Okay.
lordship.
Yes.
This is to do with a prayer for cancellation of the anticipatory bill. I will only read the relevant portion, lordship. 1, 2, 3, 4. 4 paragraphs, lordship. It is also investigated that despite several summons and warrants issued by the Honorable Court by previous CR numbers 06/2020 against accused Rajdeep Goyan, he restrained himself in complying with the court's proceedings, mentioning health issues as an unforeseen reason. I will only read the relevant portion.
So I don't know
Can you come to page 3?
What kind of language and sentences? Is it the English language?
Lordship, This is the instruction that
What
I
does it
received from
mean?
the IO.
What does it mean?
So lordship, it will be clear from page 3. If
No,
lordship
you
can-
cleared these 3 sentences, 3 lines.
Lordship, here it says that earlier that the complaint which was filed.
Who is
in
the IO?
court below.
Who is the IO?
IO is one namely ASI Nezavito
Who has
Angami.
written this?
ASI Nezavito Angami.
OC. He's
He's
the
not the
officer,
OC.
officer in charge.
He is the investigating officer in this instant case, lordship. He is the SI.
He
Yes,
restrained himself in complying with the court's proceedings, mentioning health issues as an unseen reason. What does it mean?
It means to state that lordship, if my interpretation it goes,
You have
then
to interpret. I don't know. I'm not able to understand this.
lordship. Earlier, there was a complaint that was filed below the lower court.
No, these 2 sentences I'm saying, last
Lordship.
sentence.
So on many occasions, someone was issued against the accused, but however, on the health issues, he failed to appear before the honorable court below, lordship. That is what it means to say, lordship. Lordship, may kindly come to page 3, lordship. Very important, lordship. The last paragraph, if I may allow to read, lordship.
Yes.
Now, it is clear that the complainant, Mr. Jackson Simi, on this present case, right, is police station case number so and so, had previously filed legal notice to Rajdeep Boyan through his legal counsel at Honorable Court at CJM Dimapur. However, despite numerous summons and efforts made, Rajdeep Boyan, the present accused, did not appear. So the complainant requested the Honorable Court of CJM Dimapur to withdraw the case proceeding from the Court of Honorable CJM Dimapur to further proceed for criminal case. Then the Honorable Magistrate has allowed for withdrawing of the legal proceeding of CR number 06 of 2021, but further giving a liberty to the complainant by the Honorable Court to file a fresh case against Rajdeep Boyan. Since there was no trial taken in the court of CJM Dimapur for CR case number 06 2021, because without the presence of the alleged accused Rajdeep Boyan, who never appeared before, very important, who never appeared before the Honorable Court till death to face trial and knowingly evading the due process of law, the word acquittal must have been rendered about CR case in the court of CJM Dimapur that was closed due to the non-appearance of the accused person despite numerous summons and notice issued, wherein the complainant requested to withdraw the CR case and proceed for criminal case with police. It is thus the fact that earlier and even till date, the intention of the accused Rajdeep Boyan is never to attain any court's proceeding himself or appearing before police, which shows dishonoring the honorable court's order, basing on necessary investigation and establishment of facts that the accused Rajdeep Boyan has committed cheating and criminal breach of trust. The accused is required to be taken under custody for thorough investigation. It is hereby profoundly pray and appeal before the honorable court for cancellation of the present anticipatory bail by case number AB so filed by accused Rajdeep Boyan and revoking the interim order in the interest of police investigation, lordship. So, lordship, in the earlier occasion, lordship, when that CR complaint was filed,
According to you, the court has allowed the withdrawal and acquitted the petitioner because he did not appear before the court.
Lordship, on several occasions.
So is it the law? Is it permissible? Just because the accused doesn't appear before the court, he'll be acquitted. Or the complainant or the victim files an application for withdrawal, he'll be allowed to withdraw and acquit the accused because he accused refused to appear before the court. Is it the law?
In fact, lordship may appreciate lordship that the order itself.
No, you just have to address on it.
Lordship.
There was a 275. What is that provision? 257. Under that act, under that provision, if it is allowed to withdraw and acquit from all the charges
Lordship.
of the accused, can there be another FIR or complaint on the same facts and same case,
Lordship,
same set of facts and same set of allegations, once the person is acquitted, unless you file an appeal or revision against the order of the learned trial court? There is a question actually, you should not. I don't know.
Lordship, when this complaint under 200 CRPC was filed before.
You file an appropriate application, we'll quash it.
No, we have already.
Proceedings.
We have already filed a quashing petition.
So there is no question of once you are acquitted, what's the question of bail?
Lordship, in fact,
Is there any entry order in the criminal petition?
Yes, Miller. Quashing petition. In this.
Quashing petition,
Yes, in quashing petition, there is an interim. order.
interim.
Yes.
Bail is also not required. Once he is acquitted, what's the question of having a,
Lordship, in fact.
is it a different case?
No,
Is it a
let-
different
let-
case? Is it
In the
different set of facts and different set of allegation?
Lordship, in fact, when the complaint filed before the lower court below, on the strength of legal notice, complaint was lodged against the accused. So,
Forget it. Whatever may be, you may be correct, there may be allegation may be correct. All right. But the moment he is acquitted and the complaint has been set aside, withdrawn, allowed to withdraw under 257. What is the consequences? Nothing else.
Lordship, if we go by the content, Lordship is well aware and Lordship may appreciate that if you go by the content of the.
That is the submissions. They have
Lordship.
recorded, he expressed displeasure. That despite all these things, he has not appeared. But then ultimately improvement has withdrawn the.
Yes,
withdrawn and that was allowed.
yes, Lordship, in
And he
fact,
has been acquitted.
no ratio, no principle has been laid down in this order, Lordship. When it's clearly stated that, Lordship.
They could have.
Unless you challenge this, how can we consider it? Once the trial court, it is a different thing altogether. We can take suo motu revision 401. It is different thing altogether. But then, once allowed to pass an order for withdrawal 257 and acquitted from all the charges in the case, what is the next? Either the state has to file a revision. Since you have not done anything, you just cannot go back again. I agree with you. We are not appreciating his conduct.
Lordship, in fact, on many occasions.
But
Funding, Lordship.
the trial court has acquitted him under section 257. That is, you have to argue. Even if he is acquitted and the same set of facts, a new case can be filed and the proceedings and the investigation can go. That is what you have to show. If not, in fact, bail application is also not required. It's sufficient.
Lordship, in fact. In
What's the
the
question of you have been, NBW has been issued against you.
NBW was issued, that has been stayed.
Huh?
That has been stayed.
Finish. We need not grant bail you also. There's more than enough.
Okay, then with the observation element, this bail
No, Lordship,
application may be.
if that is the case, no.
Huh? We'll come back. You think about it. I'll give you a time for reflection.
Lordship. Obliged, Lord.
You are Gogoi?
Rafiq,
Huh?
Rafiq, Rafiq. Petitioner.
Your name.
My name I Rafiq.
Huh?
I Rafiq.
Rafiq, okay.
Lordship, in that way of the matter, Lord.
You want some time?
Lordship. Since if Lordship may
But
please.
there is a interim order.
There was interim order, but subsequently it has been rejected by your lordship.
No,
Lordship, yes, they have filed one interlocutory application by submitting this, saying that the accused is on medication.
Undergone surgery.
So that was, Lordship is gracious enough to dismiss that petition, Lordship.
Because of his conduct.
Lordship, because of his conduct, Lordship. His conduct.
Where is that order of the learned Court,
Page 18, Lordship. Page 18 of the petition, Lordship. Annex 3.
yes. This is pre-arrest bail. Huh?
Lordship.
Pre-arrest bail.
Lordship.
Is there any, still, the NBW is still survives?
NBW has been stayed,
Stayed.
in quashing petition,
Huh?
in quashing petition.
Validity,
Validity.
in that case, there's no apprehension now. If NBW is stayed, huh? In fact, I don't find
Only the thing is that, Miller, this order has been passed, Miller, in view of the order passed in the AB window.
when the criminal petition will be listed.
After 4 weeks, we can.
Jimome, what to do?
Lordship, in that view of the matter, Lordship, let's come next week, Lordship, so that I will take proper instruction.
Not proper instruction. We have to argue on the law. No instruction is required. Suppose 257, if the courts allow the withdrawal and acquit the accused, whether there could be another set of the repeat, can there be second subsequent FIR or the complaint against the same set of facts and the same set of allegation on the same set of facts? Huh? Of course, that will have a bearing on that. No. Perhaps once the accused is acquitted from all the liability of the case, subsequently how you can file a complaint and how the court can take cognizance or how there can be an investigation on such a matter.
In fact, the accused, they have frustrated the court, Lordship. On many occasions, someone was issued against the accused, but on health issues or whatnot, Lordship, time and again.
Can you appear now? Yeah. Much water has already been flowed.
Lordship.
Flown.
Huge amount.
So can you Can you appear now? Within 20 days?
Lordship.
On that ground, I'll allow your bail application.
My lord, only the thing that since I have been acquitted, my lord, what is the question to appear for?
No, Lordship,
Before
if
the
you
I-
go by the. order
I
of
has
this
no
court,
right to
Lordship, No
investigate
finding, no trial has
In
been
view of the
commenced.
order passed by the
No, Lordship,
judicial magistrate.
and Lordship may appreciate Lordship. If you go by the order of the content.
Police
Lordship
cannot
is well aware,
investigate,
Lordship. There is no such trial has been commenced, Lordship. In fact, the accused have frustrated the court, Lordship, as well as the complainant.
they can
Lordship. Basing on that, basing on the.
No, can you appear
On several occasions.
within 20 days? That's whatever you are taking a thing that will be taken care in the revision petition,
Yes.
criminal petition, sorry, criminal petition.
Yes, so let bail matter be tagged with the criminal revision petition. I don't need bail.
You don't need bail.
No,
You don't do to appear.
no, no.
Lordship, then.
The problem, we can direct them to appear, but problem is prima facie.
No.
I mean, he has challenged that the proceedings and the FIR. At the same time, Planet Trial Court has acquitted it.
Then Lordship, if Lordship may, please, Lordship may allow to list the matter along with the criminal petition, Lordship. In the meantime, Lordship.
It's a,
In the meantime, I will take the necessary instructions.
sir. That is senior counsel. In such situation, what should be the? Because normally we cannot just keep on, I mean, adjourning the bail application. And the peculiarity is that the petitioner himself is saying that by filing the bail application, he don't want bail. So, Mr. Rafiq, if you don't want bail, withdraw the bail application. You withdraw the bail application. Huh? But that matter will not end here. Things are, what do you say?
If
If they are withdrawing, Lordship,
all the vacancies kept pending.
no, Lordship. If they are withdrawing,
You will withdraw.
Lordship.
Shortcut for everyone. Unnecessary.
Lordship.
But your conduct is not appreciated. It cannot be encouraged.
Both the information, both of them.
Have some counseling with your client. All right.
In fact, out of.
It may be for technical reason or maybe because of fact situation, but you cannot, this
Okay.
cannot be allowed to go on like this.
Actually, what happened, Malan?
Mr. I Rafiq, learned counsel for the petitioner, press for withdrawal in this bail application. Mr. B. Zimo Milan, PP for state present. The prayer for withdrawal is allowed accordingly. This bail petition is closed on, dismissed on withdrawal.
May I please, my lord.
Yes,
Lordship is a very short matter and
IA,
IA is.
are you pressing the IA?
Main writ petition will cover
Okay,
because after.
so
the
we'll
state-
dispose of the IA.
Yes, Lordship.
The third MS Judge Imam learned counsel for the petitioner. And also had Visokri learned additional advocate general for the state. Preparing for state respondents. MS Judge Imam learned counsel for petitioner. Submits this. She is not pressing the IA. She submits this, she is not pressing the IA. Number 90 of 2023, according to IA strength disposal. Then this is,
Published, my lord. This is an issue pertaining to backward quota, Lordship. My lord, the petitioner number 1 is from Konyak tribe.
Okay,
The petitioner number 2 is from Sumi, from Kipuri district,
all,
backward tribe.
all the respondents are representing.
Yes, yes, lordship. And PS
Okay.
is there, the state government is there.
Hmm.
The third petitioner is from Kamingan tribe. So the 3 petitioners were provided quota, reservation quota for NPSC exam. Lordship, my lord will kindly come to paragraph 2. Allow me to start reading from paragraph 2.
What is the reservation?
Reservation
First,
is,
let us see the reservation.
my lord will kindly come to
Are you relying on some notification of the state government?
notification as well as the advertisement. Advertisement is very clear. Advertisement of the NPSC. Lordship.
Can there be a whether there can be a reservation within reservation?
That is another issue, lordship. If there be that
You are from backward
backward
tribe or
tribe.
what is the state comprises of?
Backward tribe, lordship, my lord will kindly come to page.
Yes,
I will satisfy my lord.
first see the reservation policy,
Yes, 15.
15, page
A.
15.
This was issued on 20th September 1989.
Okay,
This is a notification. Whereas the period of 33% reservation policy for backward tribe in the state service was extended by this department's notification of even number dated 1st February 1989 has expired on 36/89. Now, therefore, the government has decided that the existing policy will continue till further orders. Then the second page. A1. This is 14th April, April 2011.
yes,
Dated 14th April 2021.
just wait. 1989.
This is
This 33% reservation in respect of this
all
petitioner.
the backward, declared backward
Yes,
tribe.
including the petitioner.
Yes, yes, lordship.
Okay,
Then in the second,
it has been extended.
2011 is the modification, partial modification, lordship,
Which one? Page
page A1. Next
Okay.
year, A1, page 16,
14,
16. Page
Ah.
16.
page 16, 14 April 2011.
Yes, lordship, allow me to read out. In partial modification of this department's notification number so and so dated 23rd July 2008. The governor of Nagaland in exercise of powers conferred by Article 16(4) of the Constitution of India hereby directs that 25% of all the categories, both gazetted and non-gazetted, my lord will kindly appreciate that, under the government of Nagaland shall be reserved for the persons belonging to the following 6 tribes of 4 districts of Mon, Tongsang, Kipuri, Longland with immediate effect. One is Konyak, Pom, Sangtam, Yunchunur, Chang, Kamingan. 2. Further, 12% of all the categories, both gazetted and non-gazetted posts under the government of Nagaland will be reserved for the following tribes. 1. Chakesang, 4%, Pochuri, 2%, Zeliang, 4%, Sinis of Kipuri district, 2%. 3. The 60-point roster for non-gazetted and 70-point roster for gazetted, both technical and non-technical posts are also introduced with immediate effect. The 60 and 70-point roster will be a sequence on which will go on rotation basis. Once the cycle of reservation is benefited by all the earmarked DTs. All appointment henceforth shall confirm for the new roster system. Further, all the departments should maintain a separate register for effective implementation of reservation for the backward tribes.
BT means backward tribes.
Lordship.
What is that? No other reservation for
No.
other tribe.
Only this.
No
These are
other-
the,
No other reservation.
no other reservation, Lordship.
Is it? What about this? You have 16 tribes.
No, like Lordship, Owls, Angamis, Rengmas, Lothas, and Simis. Simi, that is in general. This Simi 2% reservation is from that interior backward Kipri area settlers.
No, that's what I'm saying. That's
So five
that is a bearing. There's no other reservation for other
tribes.
other tribes.
No, Lordship. These 5 tribes are considered as general categories, advanced tribes.
Okay, there is no reservation in the state.
No other reservation.
No other reservation.
In general,
Except
in
this.
general.
Yes,
Is it?
Lordship, yes.
Is it? See, like state like Arunachal Pradesh,
Lordship.
scheduled tribe of the state.
We do have the scheduled tribe.
80%.
Of course, scheduled tribe, that is
what I'm saying.
Lordship. Scheduled tribe, that is general.
That's
General,
why I said point out at the very outset, there cannot be a reservation within reservation. That is the law of the land.
that is, therefore.
If somebody challenges it, it will go.
That
It will
is,
before.
Lordship, but that is not an issue here, Lordship.
Constitutionally, it's not permissible. They are also tribe, scheduled tribe. These people are also scheduled tribe.
Of course, Lordship.
16(4) doesn't permit that. This is amounts to reservation within reservation. 80% is there.
Lordship, that is the debate. Actually, that is the.
Not debate, that is the law.
Lordship,
It
Lordship,
cannot be permitted.
but there are
It
certain,
cannot be permitted.
the policy of the state, Lordship, it depends upon the policy of the state, and it is up to them to review the reservation quota,
No,
whether to do away with it or whatever.
lucky that nobody is challenging it, but if this is brought by this court to this the notice of this court will be said. 16(4) does not allow reservation within reservation. Then in that case, 80%, then 33, then 12%, more than 100%. Is it? Or is this the 33 or whatever 25% is from 80%?
Lordship,
Madam,
Lordship,
this 25%
Lordship.
is from, it has been taken out from 80%.
Yes, Lordship,
Huh?
Lordship,
80%.
Lordship. That is, we cannot go into details today.
No, you have to go. You have to tell us. Facts will come back, will come later.
It is the,
You make it clear about this.
Lordship, this is a reservation policy that has been adopted. I just want to satisfy my Lordship that these are the notification that has the reservation policy in Nagaland for the backward tribes.
Yes.
Here, the issue is relaxation of education qualification, Lordship. So let's go, the present issue, relaxation of education qualification, Lordship.
Yes.
So until unless I read out this, we cannot go and jump straight to the qualification issue. That's why I'm just reading out. So
you are not concerned about 25 reservation, 25%.
no, that is not an issue here, Lordship. That is not an issue here. Here in this issue, I am on
Side by side,
relaxation.
we can take into cognizance of it and we'll decide whether this is permissible under the law or not.
Relaxation, Lordship.
What is your case? Then tell me.
Relaxation of education qualification, Lordship.
Okay. You want that it should be relaxed or you want that it should
I want that we were selected through NPSC on relaxation of qualification.
qualification?
Yes.
Education qualification.
Education qualification, that is the issue here.
What is the law? Suraj Prakash.
Lordship,
The essential condition of the service can be relaxed, not the essential qualification of the service. Suraj Prakash, 2007. Have you? Do you
But
have
I'm
that? Do you have that?
That I did not bring, Lordship. It's just about the documents that is
You are asking for relaxation of the education qualification.
as for the advertisement.
No, it cannot be. If the advertisement is published, deholds the rules and the law of the land, it cannot be permitted. You cannot take advantage of that. That will amounts to allow the illegalities to be perpetuated. This court will not, court will not allow that. You cannot ask for relaxation of the education qualification.
Lordship,
Conditional service can be relaxed.
Lordship, there are certain policies of the government, state government, Lordship.
Doesn't matter.
And we are on the,
If the policy is against the law of the land and against the constitutional
Lordship,
provision,
in that case,
or
we are the only three petitioner before this.
doesn't matter, maybe 1 or 100. If it is against the law, we cannot direct them.
All those who have been selected has already been appointed.
So
In the same exam,
we'll
Lordship.
ask them to recall it. Have they been appointed on the basis of relaxation?
Relaxation also, my lord will kindly come to the advertisement.
Okay. But keeping in mind all this law, huh? You have to argue. Yes. Which page?
Page 25.
First, I'll see your, let us see your prayer.
My prayer is at page number. Thirteen.
What is impute notification is what?
Lordship, my 12 is, I'm praying for impugn class 4 of the notification dated 18/2/2010 to the extent giving relaxation of policy in respect of postgraduate teachers with retrospective effect from 27/10/2008 instead of prospective on 18/2/2010 when the notification was issued.
What is the notification?
Notification is at page 49, annexure K.
Yes.
Lordship, I have the type out copy. 50.
Is it correctly typed out?
Yes, if not, Lordship, if you want to, if my lord wants to,
No, it's,
Lordship, I think it's not a criminal code, and I think I feel that at least I will never
better.
mislead the court.
We have come across
Yes,
in
that
some
is it.
cases,
That's why,
maybe unintentional, but then it gives a, if you don't type it in very material, I mean,
Yes.
exact word and thing, it gives a, it mislead, no?
I'll confirm to the original notification, Lordship.
No,
Page
it's
49,
okay. No,
49.
I don't have, I'm not disbelieving you. I believe you. Just read it. It's okay.
Okay, Lordship, here, this is 18 February 2010. This is the policy of the government notification, that is 18 February 2010. With reference to this department's notification of even dated, even in the original, it is even dated. 10th March 2008. I beg your pardon, Lordship, this is not one, this is two, just inadvertent typing error. This is 2008.
That's why I'm saying.
Yes.
That way I'm correct. This code is correct.
Right. Lordship. I will read out from the original notification. It is legible. However, there is a little bit of black below. That's why I have typed out. Otherwise, it's very legible. With reference to this department's notification of even dated 10th March 2008 and 18th November 2009 concerning the state policy on recruitment of teachers under the Department of Education, School Education, the Governor of Nagaland is pleased to order a relaxation of the state policy in respect of candidates for the post of postgraduate subjects, teachers in higher secondary school in the state, who do not possess the prescribed professional qualification. The relaxation shall be conditional to the following. 1. Recruitment of candidates for the appointment of the post of postgraduate subject teachers shall be done through the Nagaland Public Service Commission and in accordance with the service rules. 2. The candidate must have the minimum prescribed academic qualification of postgraduate degree in the relevant subject with 50% aggregate marks, relaxable by 5% for ST/SC. 3. Every selected candidates on appointment shall undergo the prescribed professional course of B.Ed and shall complete the same course within 5 years in respect of candidates belonging to the backward tribes of Konyak, Chang, Kamingan, Yumchungur, Sangtam, Pon, Chakesang, Pochuri, and Ziliang, and within 2 years in respect of other tribes. 4. This order of relaxation shall be deemed to have come into effect from the date of issue of the first notification relating to relaxation of recruitment policy by the even number dated 27th October 2008 and shall be valid for a period of 10 years. 10 years in respect of candidates belonging to the backward tribes of Konyak, Chang, Kamingan, Yimchungur, Sangtam, Pon, Chakesang, Pochuri, and Ziliang, and for 5 years in respect of the other Naga tribes. 5. The above policy on relaxation of professional qualification for recruitment of teachers will be reviewed after the Kavichusa Committee on Reservation Policy submit its report. This has the approval of the Cabinet by the Office Memorandum number so-and-so dated 26 November 2009 and is issued in supersession of this department's earlier notification of even number dated 18th November 2009. So this is the Lordship, this is the notification, and basing upon this, the three petitioners, they were selected. My Lord will kindly come to page 21.
Relaxing what?
Qualification.
Qualification.
Yes.
What qualification?
To acquire B.Ed degree within 5 years. And here the present petitioner, the petitioner number 2 is in his final B.Ed course. The two petitioner number 2 and 3 are has taken admission this year. Although they have not been appointed, but they have started B.Ed course, Lordship. The 3 petitioners. So my Lord will kindly, this is the advertisement that is issued on 13 November 2019. And my Lord will kindly come to page 22. Here inadvertently, Lordship, serial number 16 was not in the photostat copy. So my Lord, this is the original that has been printed out. The advertisement was issued on 13 November 2019. I have annexed, but the last serial number 16 is photostated out. That's why, Lordship, that is just the original content.
Serial 16.
Serial number, yes, Lordship, 26, 27. serial number 27.
You said 16.
No, no, not 16, 27. I just want to show the 3 posts.
PGT 2 post.
27 is PGT English, 2 posts. 1 post reserved for postgraduate with at least
50% marks.
50% marks on equivalent relaxed by 5% for SC, ST different adult candidates at the master's degree level in the relevant subject from recognized university. My lord will kindly come to
The same thing?
no, lordship, indigenous inhabitants of.
You have produced and the next year same thing.
Yes, yes. What I want to say is that 1 line is missing out. That's why I just
Which one?
27 is missing in the original
No, it's there.
in the file. Maybe
It's there, it's there.
is there. Oh, I beg your pardon. It's not in my file. That's why I was concerned about that. So this is it. So in 1 post indigenous inhabitant Nagaland, 1 post reserved for backward tribe Sumi of Kipure. 1 post of English English post. Then serial number 30 is the PGT computer science. 2 posts. 1 post is unreserved, 1 post reserved for indigenous and inhabitant of Nagaland. This is computer science, lordship. Then 32. 32 is the PGT commerce. This is petitioner number 3. 1 post reserved for BT Kamen gun. So this is the
33,
32, serial number 32.
27, 30.
27, 30, 32.
We're concerned about this. Huh?
Yes, reserved for BT Kamen gun. 1 is 27 reserved for BT backward tribe Sumi of Kipuri. And 30 is 1 post reserved for indigenous inhabitant of Nagaland. So this is the petitioner number 1. Then
there are 3 petitioners.
3 petitioners, lordship. So these are the 3 posts. Now, my lord, will kindly come to page 25. Education qualification. I'm reading out from the advertisement of the NPSC, lordship. We are on this.
Yes.
Relaxation in education qualification. In respect of PG candidate not possessing the prescribed B.Ed qualification, relaxation shall be admissible to the candidates belonging to the backward tribes of Konyak, Chang, Kamingan, Yinchunger, Sangtam, Pom, Chakesang, Pochuri, and Ziliang, and Silis of Kipuri, provided the selected candidates complete the said course within 5 years. Notification so and so dated 27/10/8/9/1/2009, 18/11/2009, 10/1/2010, and 18/2/2010. The last one that I read out, lordship, the latest one. However, in respect of other Naga tribes, B.Ed qualification relaxation shall not be admissible as per school education department's letter number so and so dated 12/6/2015. 2. B.Ed degree relaxation shall be admissible for PGT in maths and physics only for a period of 5 years on the condition that the selected candidate should acquire B.Ed within 5 years of appointment, failing which further promotion service confirmation will not be given and increments stopped as provided in the new training policy. However, preference shall be given to the candidates having requisite qualification of B.Ed by the government OM dated 16/8/2016 and 23/8/2016.
Okay, the requirement of BA has been relaxed as per the policy,
Yes,
but provided you on.
I can
after
do it within
appointment,
5 years.
Within 5 years.
Yes, Lordship.
Ah,
That is the provision for
Hmm.
the three petitioners.
Hmm.
They are the three backward candidates in the
Hmm.
postgraduate.
hmm.
Now, Lordship, next is the addendum, that is page 27, D. Thereafter, addendum was issued on 27th January 2021.
Hmm.
This is the addendum. I just want to show my lordship that even other categories, relaxation was,
Other Nara tribe,
yes,
it's been relaxed.
yes,
Requirement of from BA, BEd.
yes, for requirement, that is one is physics and maths.
Hmm.
Then in 28, my lord will kindly see addendum.
All have been relaxed.
Item number
History,
51.
Education.
In education,
All
yes.
relaxed.
No, not in all, Lordship. Only education and item 52, one post of training cum research assistant under SCRT department. No, but student, I don't.
You are concerned about which subject? Hmm?
What?
English,
Commerce, computer science.
computer science.
Yes, Lordship.
Okay. So I should go for education.
Lordship will kindly come, page 29 at last clause 3. Last page, last clause 3.
Who does not possess?
Selected candidates, item number 51A, MA Education, and item number 52, MSc Physics, who does not possess B.Ed will require to complete the B.Ed course within a period of 4 years at their own expenses, beyond which they will not be eligible for further increment promotion to higher posts. I'm just trying to impress my lord that the backwards were the first priority, but I just want to impress that other subjects were also given relaxation. That is what I want to satisfy my lordship. So then page 32 and E, these are the petitioner's admission certificate, but I have just annexed it. 1, 2, the 3 petitioners, lordship. These are their admission certificates. Then 38.
Admission means for exam,
Yes, for exam.
admit card.
Yes, admit cards and other
Okay.
issued
You
to
have
the
appeared.
petitioner. Then
There's no
this is the
dispute.
notification.
Which one? Page
38. Page 38 and it's your
38.
yes, lordship.
What does it say? It's a result notification.
Yes, result notification.
Okay.
That was issued on 8 July 2022, lordship.
This you could have typed it out. It's not legible. Anyway,
My lord will kindly come to page 41 where item number 27, the petitioner R8, item number 27, 30 and 32 in the result sheet. Page 41.
yes.
Item number 27, lordship at the top. So the
Yellow.
petitioner number 2 is at serial number 2.
Yes.
BTC Nikipuri. Her roll number is 2044. Backward tribe Sini.
Anikali.
Anikali, lordship. Yes. She is the respondent number 2. Then item number 30. 1. Manto Konyak. Roll number 1718. He is the petitioner number 1, lordship. Then item number 32. Commerce.
Yes.
1. Simeon Kamingan. BT Kamingan tribe. 1845. In fact, lordship, this petitioner number 1 passed in general category. Computer science. So this is the, then lordship will kindly come to page 44 annexure G. This is the recommendation by the NPSC that was sent to the special secretary to the government of Nagaland Education Department.
Page
44 annexure G. The first, this I am directed to refer to the Nagaland Public Service Commission advertisement number so and so. Addendum corrigendum dated 27/1/2021 and to forward here with a list of candidates recommended in order of merit for appointment as notified by the number so and so dated 8/7/2022. So serial number 2, Lordship. Item number 20 is 2 posts of postgraduate teacher in English under school education. Serial number the second rank is the petitioner number 2. Then item number 28, 1 post of postgraduate teacher in history under school education department. Oh, that not that, Lordship. Serial number 30. Last 30. Item number 30.
Yes,
First Manto Konyak.
he has been selected.
Yes, petitioner number 1,
Not
Lordship.
under the quota.
No,
Okay,
even they are
Then-
mixing it
then-
up.
32.
Yes, 32.
This is
First,
under quota.
yes. Semen Kalmingan.
27 and 32 is under quota and 30 is not under quota
He,
on its own merit.
yes, Lordship,
Okay.
but still then. So this was the result, and the petitioners were anxiously waiting for their appointment order to be issued, Lordship, after passing NPSC. Lordship, in your wisdom, knows that the elite post in the state.
Which is this? Teachers.
Postgraduate teachers. Yes,
teacher.
Lordship, through NPSC. What? Page 46. Now, after this, after they passed this exam, no addendum was issued from the date when the advertisement was made on 13/9/19 and exam was conducted on 14/8/21. Nearly 2 years. In between, no addendum was issued. Not admitting, but even assuming. Then they started communicating in respect of only these 3 petitioners, Lordship. Out of all the NPSC candidates that they declared result together. My Lord, we can come to page 46, annexure H. To the Secretary, Nagaland Public Service Commission, Nagaland, Kohima. Recommendation for appointment of postgraduate teacher. Sir, I am directed to refer to your letter number so and so dated 18th July 2022 on the subject cited above, and to inform you that on careful examination of the original applications and the folders forwarded to the department, 3 of the recommended candidates, these Anikali PGT English, Manto Konyak PGT Computer Science, and Samyan Kaminga PGT Commerce.
Yes, come to the rules. So they are saying that only the physics and maths were relaxed as per the requisition. Therefore, your other subject, there's no the relaxation, is that it?
They are
While
saying that.
requisition-
We are on
while
that.
giving
We are on
requisition.
that.
What is the rule? Have you annexed the rule?
Here I did not, only the last page I found out.
What is the
So this is the original, Lordship.
what is the eligibility for
Yes, Lordship.
education qualification? If requires BA by by executive instruction, it cannot be override the statutory rules. Matter ends there.
Lordship, will come to
Qualification.
page 3. Page 3.
Qualification? Where is the vacation, direct recruit?
Page 3, that is method of recruitment.
No, qualification, let's see the qualification.
The qualification is at page 31, 8.
Graduate teacher, 7.
What's 7? 8, sorry, number 8, PG.
PG,
Yes, Lordship.
page 8.
Page 31, 31, sure, Lordship.
Okay, this is postgraduate, huh?
Postgraduate.
Graduate,
70% by direct recruitment, 30% by recruitment from lower grades. Here, Lordship, Bachelor of Education, B.Ed,
Postgraduate with at least 50%
direct
marks
recruitment,
for
postgraduate at least.
flexible 5% position. Scheduled tribe plus different level candidate the master's degree in Bachelor of Education. B.Ed is required.
Yes, B.Ed, Bachelor of Education,
Could not
B.Ed.
have relaxed.
Lordship, here, my lord, I pray before the Son of
Is there
God.
any amendment?
The,
This rule?
no, in the, my lord, we can't come here. It's provided. Lordship, come to the, come to page 3.
Huh?
They are contradicting in all the, they are providing quotas, but in all the schedule, there is no silent about the relaxation. Even in all other categories, Lordship. So, my lord will kindly come to 5.
What 5?
Page 3,
Page 3
clause 5.
of this rule.
Yes, method of recruitment. First page, first page 3.
No, method, it's okay. Qualification. What is
No,
the qualification? Education qualification or whatever qualification.
is silent, Lordship.
No,
But,
it says
no,
Bachelor of Education,
yes, here,
BA, B.Ed, BSc, ED from any National Council of Teachers Education recognized.
that's why what I'm trying to impress my lord that relaxation of qualification is
Page,
silent, but here I want to impress my lord that
where is page?
reservation for backward is page 3, clause 5, method of recruitment. The method of recruitment to post specified in schedule 1 shall be as follows: by direct recruitment or by recruitment from lower grades or by promotion or by selection through limited departmental examination. 2, subclass 2, Lordship. The respective quotas. This is very, Lordship.
Reserved for direct recruitment from the qualification.
There is-
Direct recruitment for promotion.
So under whatever circumstances we come under this.
Schedule 2. This
Yes,
is
Lordship.
schedule 2. Is this schedule 2 page 31?
31 years, Lordship.
Yeah, then
And my lord can also see in other categories, in all the, they have not, they are silent. They have provided so many relaxation, but they are silent.
what is the power of relaxation? What is the provision? Is there any power of relaxation?
No, Lordship.
No power of
No,
relaxation.
no, that's why.
Under this act, under
Under
this
this
rule.
act, I think they are contradicting the method of recruitment. Reservation quota is provided. And
Madam, sorry. By your notification or advertisement will not override the statutory rules. Proviso to 309. Law is very clear.
Lordship,
Of course, they said while sending the requisition, only relaxation was for maths and physics, not other subject. Therefore, this could not have been relaxed.
Lordship,
They
what they are submitting, what they have stated and the record.
Then we'll go by the records.
That's
Rule-
why, that's why.
Rule says, 309 rule says, you need to have BA. And the advertisement says, relax. And the office memorandum says, relax, which is not permissible under the law. This court is not saying, Supreme Court says so, it's a certain provision.
Lordship, in that matter, I may be allowed to.
So reservation, I understood, reservation part will not go into.
Lordship.
That will be said in appropriate cases. We don't want to upset the thing.
For the honorable.
No, it may not be permissible.
Sensitivity of the state with regard to this reservation quotas and all.
Will not
This
enter
is-
into that. It's okay. That's not a
Lordship,
challenge.
this is it, but first of all, this reservation quota is in all the categories of employment, Lordship.
No,
And this is not that easy and
reservation means what? Reservation what?
reservation,
Reservation of quota.
yes,
Percentage of.
percentage in the employment.
Now,
And this
under relaxation of the requirement of the rule.
under
The
the,
issue is requirement of the rule.
under the reservation comes the relaxation, Lordship.
I'm sorry.
Back for the big words.
Madam, I'm sorry.
In that matter, allow me to,
If the rule doesn't permit. That's why I'm asking, any provision for relaxation under the rule?
Lordship.
Normally, every rule has the provision for relaxation. And of course, no power has been invoked, even if there is.
Page 32, Lordship.
32,
Section 32. Our rule 32.
yes. Power to relax. Where undue hardship likely imposed to any even if, in fact, it has not been invoked, even if it is invoked, that your Suros Prakash will come in.
Lordship, the notification
The
was
condition of service
issued
can
by
be
the
relaxed, not the requirement of the service, like education qualification. Now your case is government has relaxed, advertisement has relaxed. Now government has said that it was only in respect of maths and physics. Therefore, you could not. That is not the issue. That's not considered.
in the advertisement.
We'll consider whether they under the law, the government could have relaxed, or by the notification, whether the notification or the advertisement will override the statutory rule from under 309.
Lordship, here comes
The law is very clear, madam.
Lordship, I will just allow me some time.
You submit,
Yes,
please submit. I'll give you. We'll resume at 2. Law is very clear. If you want the judgment, I'll give you the judgment.
I need to place some documents, Lordship.
Documents,
That's what
you have shown so many documents.
No.
It's either you are relying on the office memorandum, policy of the state, relaxing the requirement, qualification of B.Ed. And it is supported by advertisement. Now, rules has not been amended.
Lordship,
So the issue would be whether by office memorandum, can the rule be, whether the office memorandum, by office memorandum or executive field, can there be a provision to relax the power of the provision of the rule?
Lordship.
Or whether the executive
I need further instruction.
executive order
I need further instruction.
or the executive order or the office memorandum will override the statutory provision.
Lordship,
I'll give you the judgment and you.
Lordship, I need further instruction.
What instruction? This is the law. You have shown everything.
Lordship, I just need some clarification.
We'll continue at 2. We'll continue at 2.
No, Lordship, just
I'll allow you to argue. We'll continue at 2.
I pray that I need some instruction, Lordship. I need.
What instruction? You don't.
Documents.
No, I've been repeating. Laws doesn't require any instruction so far as the issue of law is concerned. Facts, you can ask for instruction.
That's why I need some instruction.
I have seen it.
Not only here, but
No,
I
will
need
issue
some
on the law.
instruction.
No. On your own pleading, I'll decide. On the basis of the law.
Lordship,
We'll come back at 2.
You're so confused. I just thought this. Yeah. So, the only thing is how you prioritize. Okay, what is yes, you will have somebody also. Huh?
Yes, Lordship, I picked to mention item number 135 to 139. Lordship,
We'll wait for you.
Lordship,
84.
I just humbly pray to give me one opportunity, one chance, Lordship. I just humbly pray, Lordship.
Have
In
you,
all my
have
earnest.
you gone across, come
And
across, have you checked out the law?
No, I have not, Lordship, but there are some
1962,
complications.
1967, and 2000. You find out.
There are some complications. If as
I understand it's
respondent-
not because they said it is in violation of the rules. They said only we have relaxed, that relaxation is also not permissible. In view of the
if they
judgment
say
of the
that was
Supreme.
They said that 19.8.16 as per that other subject are relaxed. We also have relaxation as per 8 to 10. That kind of complication is there. So
No,
at
there's
least
no complication.
now-
That is, if court allow your writ petition or prayer, it will amount to
just
perpetuate the illegality.
I just humbly pray that since
So
this is
by
an admission-
taking lenient view, I'll give you some more time.
Lordship.
Hopefully you'll come back with
I have-
and withdraw
I
the
have
writ
declared-
petition. I'll indicate you 1962, 67, 1967 and 2000.
And also allow me to kindly file affidavit since it is admission stage to counter, because I thought that it wouldn't go this much.
That's why you should not take risk.
Yes, yes.
For this court.
No, it's not.
In the admission stage, you must say that
Lordship.
list is for hearing.
So I want to file affidavit.
It's okay.
In
No
opposition,
objection.
opposition to the affidavit in reply, especially
It's
the
okay.
state.
There's no bar.
Lordship.
But we have spent considerable amount of
Lordship,
time.
Lordship, I beg your pardon.
Normally should not.
I beg your pardon, Lordship. There are certain complications that is very.
But I don't see any complication. This court is not
Yes,
very
Lordship.
clear.
Lordship is very specific about it. Lordship, I do understand, but here within our local circumstances, a little bit complication that has to be. I also want to see some notifications that they have mentioned.
Forget notification. You see the law first.
Lordship,
Now you have grasped your matter. You take out those laws
Lordship,
and
Lordship.
then read those laws.
I should,
We'll have to go with the law.
Lordship.
Her MSJ Genomic Learned Counsel for the petitioner. And also her citizen. No, your for respondent number? MSB Secretary, Learned Additional AG for respondent number 1, 2, and 3.
And for respondent number 4.
Yes, ma'am. Mr. City Jamit, Learned Senior Counsel, assisted by Mr. For respondent number 4. MSZ Genomic Learned Counsel to the petitioner. After arguing the matter for some time, pressed for and granted 3 weeks time. So as to enable her to have some research on the decision of the Supreme Court with regard to the present matter. All right,
Also allow me to file affidavit in.
it's okay. You
Opposition.
file. And
Okay,
she's also permitted to file affidavit in reply to the affidavit.
Opposition. Lordship. Oblige.
Pray that this matter should not come back to this court.
Lordship.
On a lighter note. Huh?
Orders. Item number 91.
Yes, again. Madam, your matter, Judge Imome.
Lordship, in view of the last order,
Yes.
I took instruction
Huh.
and I have instructions to appear for all the respondents here.
Okay. What was the last order?
I was asked to get instructions for the newly completed respondents.
You have been instruction.
Yes.
You have instruction now.
I have instructions to appear. for
So
all the
now
respondents.
with the instruction, whether this has been complied with,
Lordship, it's not yet. Lordship,
then we'll give you 2 weeks time to comply.
Lordship, for the compliance,
Is there any impossibility of compliance?
that, now,
Difficult in complying the matters?
Lordship, the government is working on
I'm
that.
sorry, order. Huh?
Then this morning, even this morning, till this morning, I have been talking with the Advocate General. Because Advocate General, the matter was endorsed to the Advocate General
For
for
opinion.
consultations, yes. Earlier also, he has given his opinion, saying that yes, this recommendation and this has to go and it has to be enforced. That was his opinion, and he still stand by it. But the matter has to be placed before the cabinet. So for that, he's working on that. So enough time may be granted to the respondent.
Matter has been placed before the cabinet.
Not yet, Lordship.
What do you say?
Now,
Lordship,
On the
the
prayer
matter
of-
is to be placed before the cabinet has been going on for a year. So how, when? Even
It's
the
okay.
respondent has been told and
It's okay. It is for 5 years, not for 1 year.
yes, it is in since 2017.
See, it's
4
since
weeks time,
2000 huh?
4 weeks time, Lordship.
Are you considering their case or
This morning,
what is the order? Let us see the order which needs to have been violated. Where is the order?
Lordship, is that they recall the Nagaland District Court Employees Rules 2017. They recalled. So while the case was pending, again they withdraw that recall letter. So, Lordship, you kindly come to page 11. The last portion, Lordship, can see 8. Paragraph 8, Lordship.
This 2000 rules
2017.
17 rules
Yes.
is in vogue now.
Yes, Lordship.
It has not been applied.
It has not been applied.
How can? Since
Since
2017,
2017.
if it is in vogue, standing rules has to be adhered to. Two weeks. It's not that you have to implement it in and by passing an order, something like that.
yes,
You have to apply wherever it is required. These 2017 rules, service rules,
Lordship.
wherever it is required, it has to be applied. It has to be adhered to wherever it is required.
yes.
So you just take a instruction. Because it's your rule only, rule framed by you only.
Yes, Lordship.
So,
Lordship.
we'll
Lordship,
give 2 weeks time.
the problem here is, at least if had they placed it before the cabinet, that is one thing.
No, it
Then
is
they
the
say,
rule has been notified. Has it not been has it been notified in the official gazette?
Yes, that rule is.
Yes, already.
However,
But then, not in the implementation part.
place to absorb those employees, 211
Okay,
employees to be brought under the.
we'll give you 2 weeks, 2 weeks.
Lordship, that matter.
On the prayer of Mr.
3 weeks time, Lordship.
3 weeks, huh?
As the last.
You try to
The advocate
come up
general
with,
himself-
get it done before within these 3 weeks. We expect that it is done, whatever you have to do should be done within 3 weeks. And Ms. So-and-so learned counsel for the petitioner, Mr. Learned counsel appearing for respondent number 1, 2,
All the response.
all the respondents, all the alleged contender, pressed for and granted 3 weeks time. Please stop. It is expected that on the next date fix, the learned counsel for the alleged respondents, alleged contender will come up with a positive result so far as the implementation of the rules is concerned.
Yes, Lordship. Lordship. Obliged.
Obliged, Lordship.
Yes.
Admission, I think one is that we follow our order.
It's one.
Admission, I think something like
What? Yes. Why?
it was to be taken up after something.
Okay, okay. Yes.
For admission, item number 79.
79. Suryan. Yes, Mr. Suryan.
Yes, your lordship, somehow I could able to get 2 citations.
Ah, Mr. Angami, why you have allowed him to construct a GA rest house on his own land, on his plot of
Yes.
land, and agreed to make a payment for the construction as well as to provide him the job for Group D post?
Lordship.
Hmm?
Lordship, in the contention of the petitioner is that.
Hmm.
However, we have denied the contention because the work order was never issued.
But then there you have, there's a correspondence from your officer.
Yes. Yes.
Are you disowning this?
No, Your Lordship, maybe because he was maybe in partnership with the firm that the work order has been issued. Maybe because of that. Otherwise, Your Lordship.
Maybe.
Yes, I have placed.
You take action. Unless you take action against this officer, how can we presume that? The
No,
word also you use is maybe.
No,
Or should we consider it and accept it as a shall be?
Otherwise,
Shall.
Your Lordship, they themselves has admitted that the work order has never been issued to them in their own petition, Your Lordship. So after admitting that, how can they say that they have completed the work?
Your Lordship, as per the affidavit in
I told you, this code is conscious of all these settled matters. It says it's not a rule, but a discretion.
Yes, Your Lordship.
So applying the discretion, judicial discretion of this code is of the view that you should approach the, I am not saying you have an alternative, therefore writ petition is not maintainable. I am just suggesting you to approach the approved forum because writ is not maintainable. Because whatever is there, it's a disputed question of facts. Whatever you have ever, it requires an evidence because there's nothing to show except your bold statement in the writ petition. And they are denying that this letter has got no value because he might be involved with you. There may be what do you call it? Nexus between you and this officer. So these all the things. I'm not saying that you have no case, but writ court is concerned not to entertain such a decision. I mean, such a petition.
Then Your Lordship, as I was submitting in the affidavit in opposition, the state had admitted that plot belongs to me, and as well as the building has been constructed. So now here this court.
Are you withdrawing or I'll dismiss the writ petition? It's up to you. There's nothing. Nobody is saying that you don't have a right under Article 300A. It's your property. You have constructed according to you.
But
Then any damage, compensation, whatever, and whatever the promise they have made according to you, you file an appropriate application and get it settled through by leading evidence, which this court cannot do.
Your Lordship,
Are you withdrawing or are you
Yes,
will
Lordship,
dismiss?
I am praying to the honorable court that I may be directed to approach appropriate forum.
I'll not direct. Nobody, there is no bar. All right. There is no bar. I can give you a liberty to approach appropriate forum.
Yes, Lord.
If so advised,
Yes.
that's all. I'm not forcing, huh? If you want to argue, I'll hear you. I have heard you also. If you want to argue, I'll argue and dismiss.
If that is the opinion of the judge, then there is no point of making argument.
What
Your Lordship, the liberty may be given to approach press.
had Mr. So-and-so learned counsel for the petitioner. After arguing the matter for some time, the learned counsel for the petitioner had Mr. Enangami, learned counsel for learned state counsel for so-and-so. Next para. After arguing the matter for some time, Mr. Suryan,
Yes,
what Suryan?
peacefully.
P. Suryan, learned counsel for the petitioner, submits that he may be allowed to withdraw the writ petition with a liberty to approach the appropriate forum. The prayer of the learned counsel for the petitioner is allowed. According the writ petition is dismissed or withdrawn with a liberty as prayed for.
Item number 117.
Is this what about this? 116.
116, given returns.
We have not passed any order.
No orders.
Good. Item 116. Hearing completed. CAB, huh? Art so and so you find out the name of earlier learning producer and government council who appeared. You appeared in one item 116 now. Which of your learning? Hearing completed. COD. Yes, sir. Yes.
My lord, it is a very simple case. A petitioner is challenging the access appointment made contrary to the advertisement. My lord,
Mukul Saikia. Rakire.
my lord,
Rakire, Mukul Saikia. On the basis of which law? Access appointment.
yes, my lord. 37 posts was advertised and 38% were appointed.
Yes.
My lord, the bad position is admitted by the state respondent. So, my lord, let me directly take your lordship to the advertisement. That is
Okay.
an X-ray page number 16.
Yes.
My lord, 5 advertisement. 11/7/2016. 37 posts of topoship grade 2 was advertised. My lord, that is it appears in item number 2. 37 posts of topoship grade 2.
Item number 2.
My lord.
Okay. You are
the
concerned.
advertisement,
You are concerned. Item
yes,
number
we
2.
are concerned here with item number 2. That is 37 posts of topoship grade.
Can you use the mic? Okay. Yes.
Thereafter, my lord, the next page, page number 17, the screening committee was constituted. The petitioner falls under number 4, serial number 4, clause 4, that is Noglak subdivision. Noglak subdivision. Screening committee was constituted. Number A was EAC convener and number B was head DP as the member. And number C, one senior DP to be nominated by the convener. So this is how the committee was constituted.
What is the method of the selection?
Oral interview, my lord.
Oral interview.
Oral interview, yes.
Okay.
Thereafter, the next page.
The screening committee was constituted.
Yes, my lord.
You are concerned with serial number 4.
For different subdivision and for different headquarters, the petitioner is from Noglak subdivision. Noglak subdivision.
You have applied for Noklak.
Yes, my lord.
Okay.
Thereafter, after the screening committee,
Just wait. Total post
total post was
37.
37.
Yes.
Total post was 37.
This is advertisement which date?
11/7/2016.
It doesn't indicate so. Date is not there.
11/7/2016, my lord.
There is no date
Yes,
in the annexure.
my lord, it's here in the second line of the advertisement. Approach government of Nagaland, approval number such and such dated Kohima, the 11th July 2016.
This is approval date.
It is advertisement date is also 11/7, my lord.
Same day.
Yes.
Very
There is no
fast.
issue on that. Yes,
Very fast.
there is no issue on that.
Okay.
Thereafter, page number 18, my lord. Page number 18. I was issued the admit card for the interview, oral interview.
Yes,
Thereafter, page number 19, annexure D. This is the
select.
approval list.
Hmm.
So in this approval list, 38 persons were approved for appointment. 38 persons were appointed, approved for appointment.
27, 38 total.
Yes, my lord.
This is for
This is for Topashi.
Gauhati, DB. Huh?
Yes, my lord.
What is the name of the post?
Topashi, grade 2. Topashi, grade 2, under Pinsang district.
This was the 15/6.
Yes, 15, 16, December.
You are not concerned about the second column,
Yes, my
second
lord.
box.
My lord,
Gauhati, you are not concerned.
I'm concerned only with the first box.
This is grade 2. You are concerned about grade 2 only.
The next column is waiting list. Waiting list.
Hmm? Okay. This is waiting list. Okay.
So thereafter, the petitioner,
Hmm.
after coming to know that he was not selected,
Hmm.
has applied for RDIs, but no information was provided to the petitioner.
Ah.
My lord, since the matter has come before this honorable court, let me not go into that RDI thing, because no information was provided. So thereafter, coming to page number 22, my lord, annexure F. By this appointment order,
Hmm.
3/7/2017.
Is another challenge?
Yes, my lord. This is the MPN appointment order. 19 persons were appointed. These are fresh appointment. These 19 persons, they are given fresh appointment.
Yes.
And by the next annexure,
Hmm.
that is on the same day, annexure 3, page 24. On the same day, 19 persons were regularized. 19 persons were regularized. So by making this MPN appointment, 19 persons fresh appointment and 19 persons regularized, 38 persons were appointed altogether, contrary to the advertisement.
Yes.
And when the petition was still pending, I have made a prayer for calling the report.
Hmm.
Because it is the contention of the petitioner that there was no transparency in the interview conducted by the district selection committee. So the result on 1st of March 2021, report was called forth by this court.
Hmm.
So the report is before this honorable court, my lord. And my lord, the state respondents, they have filed their affidavit in opposition. And in their affidavit, at para number 5, we have admitted that access appointment has been made.
By
State affidavit in opposition on behalf of respondent number 1 to 16.
1 to
1
16.
to 16, yes, my lord.
Okay, state respondents.
Yes, my lord.
At page.
Page number 3. Page number 3. My lord, I will be allowed to read the relevant portion, that is the
Yes.
second para. However, on perusal of the reports, it is found that one post which was not advertised has also been utilized due to oversight. The said post is the resultant vacancy of Sri Kumpise Sangdam, Special Grade DB, ADC Office Longkem, who retired on 30/6/2016. And against this post, Sri Y. Sachongli Sangdam, son of Im Kumong Sangdam, was appointed as DB Grade 2, white order number such and such, at serial number 12, fresh candidate. So the state respondent has admitted that the access appointment has been made contrary to the advertisement.
So what have you done? If you have already, you have admitted that the exchange appointment has been done. That too in a different post, huh? A special grade post is
No, my
higher
lord,
post
no,
than the
that
grade
is the
2.
retirement post. That is the retirement post.
No, but then special grade DB is higher post than grade
That is the
2.
retirement post, my lord.
Yes. That has not,
Yes.
which has not been advertised. This is higher than the grade
Yes.
2. Isn't it?
Yes.
Is a higher post, special grade or lower. I have come across somewhere.
Special grade.
First is DB, then grade 2, then special,
No.
then. Huh? Huh? What is the hierarchy of post? Hierarchy of post in this grade 1. Okay. DB, then grade 2 DB, then special grade DB, then grade 1. Is this the hierarchy?
No.
Anyway, let us not confuse ourselves. Special grade DB is higher than the DB grade 2.
Yes.
Or is lower?
Higher.
Higher. So what have you done? He is the respondent, private respondent.
My lord.
Lordship, they are the private.
Prosecco, you are appearing for respondent,
I'm for respondent.
private respondent, only one respondent.
Correspondent.
Huh?
Worship.
You are the
Private
you are the access person.
My lord, he is representing the whole private respondent. All the private respondent.
Why private respondent?
My lord, I have challenged all those appointments. Because my lord, I'm
Now will not interfere all those.
I'm questioning the transparency involved in the selection process. That is how on the prayer made by the petitioner, the record is.
Will consider, I will accept your argument on the ground that there is an access appointment. Last man has to go. Not all. Because you know, it involves certain amount of time and energy and the finance of the state, which will be from the exchequer, public money, for interview also.
Yes, that it is.
Even for oral interview, you have to take tea, lunch.
In fact, petitioner also was answered.
No, that's why I'm saying will not interfere. 37 posts, last one has to go. Where is the judgment? Mukul Soikia,
My lord, I have
2008.
brought 2005, volume 4, page number 154.
Name of the party?
Secretary, AB Public Service Commission versus Sobana and others.
There is a 2008 judgment also from our Gauhati High Court. Supreme Court, Mukul Soikia. Yes. Para?
My lord, para 10. Para 10. At page number 158.
Then
Then para 13, my lord. Para 13. Access appointment can be made only with the policy decision of the government. And in the present case, there is no such policy decision to make access appointment. Then the number of post advocates.
I think this 2008 has cleared in this. Even by policy, you cannot, because as well as Article 14 and 16. No access appointment, local Serbia and then thereafter. And so far as the other issue is, what do you call it? Changing the rule of game has been, I think, placed for larger banks for further consideration.
Yes, madam.
Recently.
Yes,
Local Serbia, you find it out, I think 2008.
my lord, I'll do that.
I would also like to place.
That's all.
My lord, yes. The prayer of the petitioner was to
What?
verify the records that has been brought before this court. And if things are not found in accordance, then prayer of the petitioner is to quash and set aside the whole appointment. All the appointments that were made.
Will not interfere. So far as 37 is concerned. Last man will have to go. 38, number 38 has to go. All right. That's all.
My lord.
If they have admitted, why you should look into the record? Yes.
Learned counsel for the petitioner has rightly pointed out with regard to the paragraph that
Use the mic, please.
which we have stated. Which we have stated that yes, inadvertently, one access appointment was done, and then on the last occasion by the Honorable Court has also directed the state to file an affidavit to bring on record as to how the access appointment was made. And on 14 June 23.
This additional affidavit.
Lordship, and an affidavit filed for on behalf of respondent 1 to 16 by bringing on record as directed by the Honorable Court order dated 13/3/23 and 35/2023. There we have mentioned that more particularly paragraph 3, page 3. One access appointment.
Where it is?
An additional affidavit filed by the state respondent on 14 June 2023, Lordship. The state respondent filed an additional affidavit, Lordship, bringing on record with regard to the
Where it is? Yeah. This one. Yes.
page 3, paragraph 3, Lordship.
Yes.
Here lordship is mentioned, married lordship. That answer, deponent begs to state that the additional deputy commissioner, Tingsang by letter dated 10 April 2023, intimated the matter to the undersigned authority. That is the Commissioner Nagaland, stating that the incumbent Sri Y. Samsuli Sangtam has participated in the DLRB interview pursuant to then advertisement number 1, dated 11/7/2016 to the post of DB grade 2 under Tingsang district lordship. So we are also admitting to the fact that there was an access appointment inadvertently committed by the state respondent lordship. To that effect, lordship, there is a Supreme Court rulings lordship which says that even if I would like to say that before lordship. It's 2001 two Supreme Court cases. So the lordship, I have annexed some of the citation also, lordship. Lordship, I will only read the relevant paragraph, lordship. Lordship may kindly come to page 201. 201. This is page page 201, paragraph 34. Start relevant paragraph start from 34, lordship. Yes. Married lordship. From paragraph 34. It is also not the case of the appellant that there are amongst 22 candidates in the order of merit published by the second respondent awaiting appointment in reference to an advertisement dated so and so, and if their submission is accepted at the face value as prayed for, at least the present appellants may not get a march over 22 candidates waiting in the order of merit who in the ordinary course could claim appointment to the post of sub-inspector, and the action of the state in extending its concession, which has been recorded under the order of this order dated so and so, is indeed the mistake being committed. Still, it cannot be forced by the person as alleged to be aggrieved to perpetuate the said mistake. 35. This court in Union of India versus Kartik Chandra Mandal observed that if something is being done or acted upon erroneously, that cannot become the foundation for perpetuating further illegality. If an appointment is made illegally or irregularly, the same cannot be made the basis of further appointment, and erroneous decision cannot be permitted to perpetuate further error to determine on the general welfare of the public or a considerable section. This has been the consistent approach of this court. 36. In Arup Das versus State of Assam, this court observed that so and so, para 19, even if in some cases appointments had been made by mistake or wrongly, that did not confer any right of appointment to another person, as Article 14 of the Constitution does not envisage negative equality, and if the state had committed a mistake, it cannot be forced to perpetuate the said mistake. 37. It is undisputed that by the time we are called upon to decide the matter, the so-called 22 candidates against whom there is a list raised by the present appellant had completed almost more than 12 years of service, and thus having rich experience in the field, and subsequent selection has also been held on the post of sub-inspector pursuant to an advertisement issued in February so and so, and the constitution which was recorded of by the learned Advocate General of the state by this court in his order so and so at a given point of time also appears to be a bona fide to give purchase to the ongoing litigation in the courts for sufficient long time, and no other litigation at that given point of time was pending in the court of law. In the given situation, this court is not inclined to disturb the appointment of those 22 candidates, which has been questioned by the appellants candidates in the present batch of appeal. Next page, lordship. 38, paragraph 38. Para 30. In Gujarat State Executive Engineer Association versus State of Gujarat, this court recorded a finding that appointments given under the wait list were not in accordance with law. It is, however, refused, more important, Lordship, it is, however, refused to set aside such appointments in view of length of service 5 years and more, Lordship. Here is a case, Lordship, where the private respondent, the respondent, they have served more than 5 years, Lordship. 39. In Budnath Chaudhary versus Abhi Kumar, this court has observed that appointments were held to be improper. But this court did not disturb the appointments on the ground that the incumbents had worked for several years and had gained good experience. 6. We have extended equitable consideration to such selected candidates who have worked in the post for a long period. 40. We are also of the view that the appointment of 22 candidates met by the second respondent by order so and so, not relevant to which has been given rise to the further litigation, are irregular appointments and not in conformity to the recruitment rules. Still, what is being prayed for by the appellant, if accepted by this court, that will perpetuate the illegality which has been committed by the state. The respondent and negative equality cannot be claimed to perpetuate further illegality under Article 226 of the Constitution of India.
We are not granting relief to him.
Laws.
We are only on excess appointment.
Laws.
These are by Supreme Court, facts on big matter. Facts of the each matter, this has been.
Laws.
Facts and circumstances of the matter. It has been decided by Supreme Court by power of Article 122 to complete justice.
Lordship. So here is the case where the
So there you had committed mistake by appointing 38 candidate.
Lordship.
So it should be allowed to continue. That is what you are saying.
Lordship. That is what my.
Why it should be? Then what's the meaning of no appointment beyond the post advertised?
In fact,
Which violates Article 14 and 16.
Lordship.
Honorable Supreme Court can always do that.
Lordship. That is my submission, Lordship. I cannot go beyond that since we have already explained in our paragraph, Lordship, that erroneously we have committed a mistake.
You have said that you have admitted that
Lordship.
inadvertently you have appointed.
Inadvertently. Lordship.
Now filing an additional affidavit, you are saying that he appeared for the respondent number, the 38th person.
Lordship.
What is the respondent number?
Respondent
It is respondent number 28.
Huh?
Respondent 28.
28.
Yes, Lordship.
in the present petition.
In the present date petition, he is respondent number.
Respondent number 28.
Lordship.
He appeared for the first.
Lordship.
Therefore, he has been selected.
Lordship.
How can you have that contradictory statement? or not?
Lordship, he appeared for the exam, Lordship,
Hmm.
for the interview, Lordship. However, one post which was reserved for compassionate appointment, Lordship, which was not advertised by the respondent, Lordship, that was inadvertently appointed the respondent number 28 in the present petition, Lordship. That is our stand, Lordship. That is our stand.
Please continue.
So basically, that is our stand, Lordship.
So you want that this should be
Lordship.
allowed to continue?
Lordship, since he have served more than 5 years, Lordship, and there is a settled principle of law which has been laid down by the Honorable Supreme Court.
It's not a
says-
certificate, on that facts only, it was.
It says that Lordship, since the petition, the respondent, they have served more than 5 years, Lordship. So the Honorable Court has not interfered in the quashing of the appointment. So even though it is irregular lodge. So basically that would be my submission lodge.
That is by the Supreme Court under Article 142. Applying to the High Court doesn't have the power.
Our lodge. Our my submission never be recorded lordship because lordship earlier
Use the mic.
our lordship 37 posts was to be advertised lordship. However, inadvertently one post which was kept reserved for compassionate appointment was inadvertently appointment was given to the respondent number 28 in the writ petition lordship. So lordship, basing on that lordship, in support of my submission lordship, I'm relying on the 2021 lordship.
Even if the mistake is committed, can be allowed to continue.
Lordship,
It can be retained in the job.
lordship, that is what the Supreme Court says, lordship. So I'm relying on that.
Supreme Court didn't say. Supreme Court says by applying the power under Article 142 to complete justice.
Lordship,
High Court doesn't have that power.
lordship. I'll leave it to your lordship.
Next, lordship, in respect of the other respondents, the respondents of the expertise advertisement have ordered our applications, and we have sit for exam, and we have sit for the interview, and we were selected lordship according as per advertisement. So lordship, my humble prayer is that this honorable court may not interfere with the period of the petitioner to quash the appointment of the respondents, which were done as per constitutional provisions of the for employment, by which the advertisement was made. The petitioners, along with the respondents, have applied, and the respondents have come through the exams. My humble prayer is that the prayer of the petitioner is not maintainable for question of the appointment law. Moreover, lordship, when the petitioner lordship has participated in the exam, has faced the exams, and the screening is conducted by the district.
You are for 17 to respondent number 17 to
Lordship, all the respondents, lordship.
17 to all 12 respondents. Just find out.
Lordship.
So 17 to
54, lordship.
54.
Lordship.
Yes. What is your submission?
Lordship, my humble submission that
Petitioner is
the petitioner doesn't have locus, lordship. As much as petitioners has also participated in exams, but on being not selected in the selection process, they are challenging the appointment of the respondents before the court.
He cannot challenge.
You cannot challenge lordship, or else you should have challenged.
Agreed.
Lordship.
But problem is excess appointment.
Lordship.
Beyond the first advertised.
Lordship, the
27 posts, sorry,
37.
37 posts,
37 posts were advertised.
and they have appointed 38. It's one post excess.
Lordship.
Last man has to go. Unless he agrees that when the petitioners, I mean, accept that, let him be continue since it's been 5 years.
Thanks, the respondent.
Anyway,
28 is serving. In
What-
post
what-
over 60.
what benefit will you do by throwing him out from the job?
The post will be advertised again.
You will be allowed to.
I'll also participate in the same selection.
So he's so vehement. He's adamant.
Actually, the petitioner, the respondent 28 has been serving in the post for over 6 years.
Doesn't matter. You may approach the Supreme Court. We don't have the power.
Lordship, first of all, my humble submission is that the petitioner doesn't have any locus, the process on the court when he has participated in the selection process.
I would consider. He may not, but so far as the excess appointment is concerned, he has the right to participate again when it is advertised.
And secondly, with respect to the respondents,
The last man responding to 28 and the petitioner will participate again.
Lordship,
And
with respect to
obviously government will select you. It's an oral interview. Huh? See? Okay, what is saying? He said yes. He'll advertise, allow both of you, will have an interview and appoint him.
This will be recorded. My lord, on the locus of since the respondent is challenging my locus, my lord, I have a citation, 1996, volume 4. SCC. For 11 in 12.
Ruplal.
Prem Singh.
Huh?
Prem Singh.
Prem Singh.
Yes, my lord.
Yes. Paragraph.
My lord, paragraph 11, page number 325, paragraph 11. My lord, the last, starting from the last 6 line, he further submitted. He further submitted the last 6 line.
Para 11.
Yes, my lord. The last 6 line, he further submitted that the High Court should not have quashed the selection and set aside the appointments at the instance of the original writ petitioner, as in any case, you were not selected by the selection committee, and therefore you were not likely to get any benefit by getting the selection and appointment invalidated. The learned counsel also questioned the locus standi of the writ petitioner, as all of them except one had taken part in the process of selection without any objection. They also pointed out that the petitioner number 3 in the WBC number such and rate petition number such and such was not even eligible to be considered for the post on the last date for receiving applications. Part 12. In our opinion, there is no substance in the objection raised with regard to locus standi of the original rate petitioners. The candidates could have anticipated when they appeared for the interview that the selection committee would recommend candidates, and the board would make appointments far in excess of the advertised post. The petitioner who was not eligible had just a grievance that due to the appointment of the candidates in excess of the post advertised, he was deprived of the right of consideration for appointment against the post, which would have become vacant after the acquired eligibility. So the contention of the respondent that the writ petitioner had no locus was rejected.
On locus, you don't have a case law
No, Lordship.
that
But in respect of the other respondents,
1992, there's motherland versus state of Jammu and Kashmir versus motherland. That's all.
what's it?
We'll dispose it of. This. How many meters? 1, 5, 6, 7. Let us see what is the item which year. We can do 19. 127. 127. 35. 150. This one is this. It's so voluminous. Any other case law here?
Other days which have been reflected in 2021.
Okay, okay. Which they have relied. I mean, referred that, no? Heard Mr. Takar Kishu, learned counsel for the petitioner. Also heard Mr. B.G. Mohammed, learned district counsel for respondent number 1 to 16, and also Mr. Kosiko 44, respondent number 17 to 54. By filing this petition, the petitioner, only one petitioner,
My lord.
just take your seat. The petitioner has assumed the selection process held on 8/11/2016. And the held on 8/11/2016 for the first of DB. Advertisement is page
My lord, page 16.
DB grade 2.
My lord.
Your prayer is something different. DB grade 2. Pursuant to the advertisement dated in July 2016. Annexure 16, huh? Annexure A, page 16, advertisement, huh? And the consequential government approval dated 15/6/2017 for appointments of 38 as well as the appointment orders dated 3/7/2027 whereby altogether 38 GB grade 2 have been appointed on the ground that the appointments appointments have been made in excess of the post advertised. as the post of, as in terms of the advertisement dated in July 2016. Altogether, there were 37 posts of DB grade 2. However, 38 DB grade 2 have been appointed by the state respondents and also phase 4. First interview, first there were praised for questioning of the entire selection process and for first interview in respect of the 38 post of DB grade 2. The next paragraph. The case projected by the petitioner is that the Deputy Commissioner Kwensing District issued an advertisement that it will say nil dated 7 July 2016, inviting application from the candidates belonging to the indigenous inhabitants of Kwensing District for filling up of 37 DB grade 2 posts, along with other grade 4 posts. Pursuant to the advertisement, the Deputy Commissioner has constituted a screening committee by the order dated 3/9/2016 for the district headquarters and subdivisions to conduct DLRB 2016 for various posts of drivers in grade 4. In accordance with as per the, is it as per the rule? Oral interview and all.
My lord, yes.
As per the rules, what rule it is? There's no rule. All these selection process are conducted
Normally for the administration, lordship.
It's a general kind of thing.
Lordship. The approval has to come from the commissioner and then commissioner.
Is a
after-
practice, no
Yes,
rules.
lordship. DLRB.
There's no rule.
District level recruitment board, they
If not rule, at least guidelines. Do you have any guidelines?
yes, lordship.
Where it is? I know in accordance with the prevalent practice. We'll see that. If you can show something, some guidelines or rules, how they are appointed, advertisement, it's okay. General principle. But then how it is conducted, because reason is,
Lordship is
as I pointed out in the later note, there's a chances of manipulations are there. It's only oral interview. There must be some guiding principle.
it's a prevailing practices, lordship.
As per the prevailing practice. Huh? Thereafter, the screening test was conducted on different dates at different 4 sub-divisions under Kwensing district. The petitioner is from Nokhlak subdivision, and for the Nokhlak subdivision, screen test was conducted on 20/10/2016. Next, the result was declared, the result of the speed test was declared on 24/10/2016 by the DLRB 27. Since the petitioner was declared qualified for the in the screening test. For the screening test, a call letter was issued. Which was to be held on 8/11/2016 for oral interview. According the oral interview was conducted at Sing Deputy Commissioner Office. And the result was declared on 22/6/2017. This tribe-wise base will not record it. It's unnecessary. It has no bearing.
Yes.
Correct? Yeah. So in the result 22/6/2017, your name is not there. Okay. After the what is that result?
Well, that second result is not annexed. It is not annexed. I have annexed the approval at page number 19.
19.
Yes, my lord.
Next one I have. After the declaration of result, it was sent for approval by the government. Then this is the government.
Yes, my
approval.
lord. Yes, my lord.
After the declaration of result, then it cannot be 22. No, you are wrong. This is result was declared on when? This approval letter is of 15. How can the result be declared on 22? 22, you have received, deputy commissioner has received back the approval. You just delete that 22, huh? Mistake. After the declaration of the result, it was sent for approval by the government. Mr. The Assistant Commissioner by letter dated 15/6/2017 has conveyed to the Deputy Commissioner the approval of the DLRB 2016 result for Sing district, which consists of 38 candidates to be appointed as the versus grade 2, including name of the 10 candidates on voting list. Thereafter, By the order dated 17, is it? A third
37, my lord.
2017. Same day,
My lord, same day.
Annexure 24. The deputy commissioner has appointed 20, this is 19, huh?
19, my lord, 19.
19 membership, 19 candidates. These are all respondents,
My lord.
Candidates.
Nineteen candidates were appointed and 19 were regularized.
Before that, huh? You just delete that next one. Pursuant to the approval dated 15/6/2017 by the government. The deputy commissioner has appointed altogether 38 candidates for the post of in the post of DB grade 2. That is 19 posts. 19 persons as first candidate and another 19 candidates on as a by way of regularization.
Yes.
Next one. Mr. Tata that counsel for the petitioner submits that since the total number of posts advertised was 37 posts, 37, whereas by approval and selection and the appointment are of 38 posts. One more post, which is what excess of one more post. Therefore, it is a certain position of my that the authorities it is a certain position loaded. No appointment can be made. On a post which is about the post more than the post advertised. Therefore, the entry selection process will be satisfied and the fresh advertised be issued so as to enable the petitioners and other eligible candidates to participate in the selection process. First, Mr. Next one. Mr. Bijibabi, Mr. Akakichu, learned counsel to the petitioner. Is that it? First judgment has placed reliance on the
2005, volume 4. One five four.
Honorable Supreme Court in the case of Secretary, AP Public Service Commission versus B. Christoph Swapna. B. Swapna and others reported in 2005, volume 4 SCC 145. 154. 154, no?
Yes.
Paragraph
Paragraph 10 and 13.
10 and 13. Ten and 13, yeah, you will just go ahead. You just don't give all this thing, huh? Para 10, huh? There are two principles in service laws which are indisputable. Mr. Firstly, there cannot be appointment beyond the advertised number. And secondly, norms of selection cannot be altered after the selection process has started. That's all. Just up to that. And the para 13, the legal position so far as the you just quote the para 13, right? In 1996, 4 SCC, yeah?
My lord. Page 319.
1994 is page 319, paragraph
Paragraph 11 and 12.
11, 12. You just got 12, huh? Not 11. Next para. Mr. B.J. may be learned counsel for the respondent, state learned state respondent, learned counsel, learned state counsel. Fairly submits that not that state counsel, while referring to the affidavit filed on behalf of the state respondents, fairly submits that one post which was not advertised one post admittedly which was not advertised has also been utilized due to oversight.
Which was kept for compassionate appointment.
Which was kept for compassionate appointment. And against this post, Sri Y. Tajungli Sangtam. Respondent number 7, A28.
Respondent 28 in the
Respondent number 28 in this present petition, in this writ petition has been appointed as DB grade 2 as a fresh candidate, though the vacant post is special grade DB. Mr. That's all. No. By next, Mr. V. Zimbabwe, London State Council. Where is your additional affidavit?
additional.
Yes. At the same time submits that. The respondent number 28, Sri Y. Tasanglu Sangtam. Has participated in the DLRB interview pursuant to the advertisement dated 11/7/2016 for the post of DB grade 2 under Tuensang district. That's all you are saying, trying to say that whether he has participated or not.
Logic.
Logic. He further submits that though there is a mistake on the part of the state respondents in appointing the respondent number 28, is he a last man in the thing? The merit list?
No, Lordship,
Who is the last man?
he is not,
According to you, who is the last man? Respondent number 28?
No, my lord.
no,
Who is the last man?
The respondent number 28 is that person by which that post which was not advertised was filled up.
Okay. So then it may violate the merit system also. According to this code, the last man has to go. Is the selection in merit basis, on merit basis?
Lordship, it is on merit basis, Lordship. Lordship, one post which was kept for compassionate appointment.
Understood.
And then Lordship, though he faced the interview that responding to the Changsuli Sangtam.
No, what I'm on is whether is it the last man in the merit list?
No.
Then?
No.
And you have to redo it again. In that case, we'll set us an enter selection process.
Lordship, regarding the rest,
After
37
you approve
37
this,
was.
Is it the selection list on the basis of the merit?
Yes, Lordship, as far as 37 advertised post is concerned, it
Then 28 cannot go if it is on merit basis. Selection list on the basis of the marks obtained. Is it on the merit basis?
Lordship, yeah, the issue is like this, Lordship. 37 post was approved by the Commissioner Nagaland. However, the Deputy Commissioner Tensang has advertised advertised 37 posts. On 37 posts, while the approval was sent, while the interview, after conducting the interview, while it was sent it to the government for approval, 38 names were sent it to the Commissioner Nagaland Lodge. So one post, which was not advertised, was kept for completion.
Understood. I'm not on that. What I'm on is, what is the selection process? Your approval, there's 1, 2, 3. Is it on merit basis?
Lordship, it is on merit
random.
basis. It is on merit basis.
Then you have to appoint this 2000, this respondent number is not the last man. If it is not merit basis, who is the last man? Let us see.
If we are to go by the submission of the learning council for the
Let
state,
us see.
the last name will be respondent number 35.
Yes. Page.
Page 20, my lord.
Yes.
The approval. It starts from page 19. If we are to go by the submission of the learning council for the state, the 38 is Mobang Sumba. And he appears it's respondent number 35 as respondent number 35.
Do you have the records?
Lordship.
So the records, do you have the records?
Lordship.
So the selection list, you find out the selection list. Anyway, we'll continue. Find out the selection list, whether the selection is based on merit or not. Or it is just a random. What is that? Find out the record from records, whether this is. Mr. Limo, next para, learned council, learned state council. While relying the judgment of the Supreme Court in the case of Pankeshwar Sharma versus State of Jammu and Kashmir, reported in 2021 to SCC 188.
Lordship, in order to make things clear, Lordship.
Yes, yes, yes. There are 34 and 35, huh? You just note down, huh? But then you just give it. Relying so and so, huh? And submits that even if in some cases appointments have been made by mistake or wrongly, that did not confer any right of appointment to another person, as Article 14 of the Constitution does not envisage negative equality, and if the state had committed a mistake, it cannot be forced to perpetuate the said mistake. Para 38. And further submits that since the Honorable Supreme Court though found the appointment in some cases not in accordance with the law, has refused to set aside such appointment in view of the length of service in the case of Gujarat State versus State Deputy Executive Engineers Association versus State of Gujarat. As in the present case, the private restaurants have been serving since last more than 5 years. 5 years,
6 years, 6 years,
more than 5 years,
6 years, 4 months.
more than 6 years. Mr. Therefore, though there is a mystery on the part of the state respondent, this court may not interfere in the selection process, and the respondent private students may be allowed to continue in the service as per their selection and appointments. Then Mr. Fosiko Pote, Learned Counsel, appearing for respondent number 17 to 54.
Lord,
Submits that the petitioner has no locus standing filing this writ petition, inasmuch as he has participated in the selection process pursuant to the advertisement dated July 2016, and he has not been selected. Therefore, after participation in the selection process, when the result is not palatable to the petitioner, he cannot turn around and challenge the selection process as being bad and illegal. Any judgment? No.
no, Lord.
For future reference, that Madanlal versus State of some 1993 supplementary session.
Yes, Lord, got it.
Got it?
I've got it. No, no, no.
Next. I have considered the submission of the learned counsel to the parties and materials available in the court. Having considered the issues at hand, apart from besides other challenge, the issue needs to be decided is whether there is an excess appointment over and above the post advertised. Next paragraph. It is not disputed that advertisement dated 7/2016 provides for inter alia provides for total 37 posts of DB grade 2 to be filled up in the district of Twensen. It is only entire district for Twensen. Accordingly, the selection process was conducted for the post of 37 for 37 post of grade 2 DB. Next paragraph. The deputy commissioner has sent for after the selection process, the selection list was sent for approval by the.
Sorry for the indulgence, Lordship. Page 19, which says, Lordship, there is in service, Lordship. In service candidate is also there and fresh candidate is also there.
No, that we have seen. Advertisement says what? Let us just check.
Page 16.
It's 50-50. 50% from first candidate and 50% from in service as contingency. Huh? That's good. Before that, just delete that last line. The advertisement. In the advertisement, it prescribes that all the vacancies shall be filled up on 50-50 basis between the in-service, i.e. contingencies, public ad hoc, public contract, public fix, etc., and fresh candidates. The next paragraph. The deputy commissioner thereafter send the select list for approval by the government consists of 19 fresh candidates and another 19 candidates from in-service. Thereafter, the government conveyed the approval on by order that 15/6/2017, whereby altogether 38 candidates have been approved for appointment in the post of DB grade 2. Next paragraph. Finally, by the order dated 3/7/2017, the deputy commander has appointed the private respondents in total 38 persons. That is IA 19 from 19 from fresh candidates and another 19 from in-service. On consideration of the above facts and the materials, there is no doubt that the responding authorities have appointed 38 candidates, which is candidates, which is more than the post advertised, as the advertised post was of 37 post of DB grade 2. Next one, it is certain position of law that filling of vacancies over and above the number of vacancies advertised would be violative of fundamental rights guaranteed under Article 14 and 16 of the Constitution, and the selectees could not claim appointment as a matter of right. In this regard, I may appropriately refer to the case of Mukul Sekhia versus State of Assam, reported in, I'll just give you the settlement, 2008 SCC. I'll give the settlement. Next page. Yours is paragraph 34.
Paragraph 34.
24.
34.
What do you want to say here?
Lordship, 35. 35 in the Union of India versus Kartik Chandra Mandal says that if something is being done or acted upon erroneously, that cannot become the foundation for perpetuating further illegality. And moreover, Lordship,
It is there would not next paragraph. There would not be any disagreement to the observation made by Honorable Supreme Court of India in the case of Union of India versus Kartik Chandra Mandal, that if something is being done or acted upon erroneously, that cannot become the foundation for perpetuating further illegality. Mr. If an appointment is made illegally or irregularly, the same cannot be made the basis of further appointment. An erroneous decision cannot be permitted to perpetuate the further error to the detriment of the general welfare of the public or a considerable section. And however, in the present case, this court has not been called upon to decide that since there is illegal in appointing, the petitioner should be appointed. Rather, the issue has to be decided with is whether there is an excess appointment over and above the post advertised. Mr. Next paragraph. It is not disputed a debate that and cannot be, as the advertisement clearly speaks of a prescribe of a provides for 37 posts of DB grade 2, and the appointment and selection have been made of 38 numbers of candidates, including the fresh candidates and the in-service candidates, which clearly shows that there is an excess appointment of one post over and above the number of posts advertised. Next paragraph. Accordingly, in view of the above, it is clear that, since there is an excess appointment of one post over and above the advertised post of 37, this court is of the view that the excess appointee cannot be allowed to continue, as it amounts to as it would be against the law enunciated by the Honorable Supreme Court of India, and also in violation of the Article 14 and 16 of the Constitution of India. Then what is that?
Or lordship.
Last man, who is the last man?
My lord,
Huh? Is it on merit?
my lord, if you may kindly come to page number 19 of my writ petition.
19.
Yes, my lord. Page number 19. My lord, this is in order of merit.
Yes.
Proportion in order of merit.
What it says? As per the district level of the government, what is, where does it say?
My lord, the one that is in black color, proportion in order of merit.
Okay, okay,
My lord,
okay.
if my lord has followed it. And in this case, the serial number 38, this will be the last name. And this
Next period.
this is the respondent number 35.
Having been held that having been concluded that next para, there is an access appointment over and above the post advertised. The next issues would be whether who amongst the private respondents would not be entitled to continue in their service in view of the fact situation of the matter. For which the learned counsel for this petitioner has pointed out that the approval and the selection list, approval of the select list is in order of merit. Therefore, is a fresh candidate.
It's a first candidate.
The last man, that is respondent number
35.
in the merit list 35. You just name give the name. Huh? C Ngopo Samba. Huh? Huh? Is that it?
No bang samba. No bang samba. Sing no bang samba.
No, he's in service.
No, my lord. Trace. From serial number 20.
Okay,
from serial
okay,
number 20 is
okay.
trace.
So and so. Respondent number 38
My lord. 35 in the present
35
petition.
in this presented petition has to give way for fresh advertisement selection. Next para. Having regard to the submission of the learned counsel for the private respondents. Taking note the objection on locus, this court is of the view that it's not a question of questioning the selection process as such, but a clear violation of the law laid down by the Honorable Apex Court, as well as the violation of Article 14 and 16, wherein admittedly the respondent authority has appointed it's a case of excess appointment over and above the post advertisement. Therefore, the question of locus as raised by the learned counsel for the private respondent has been considered only for rejection. Your submission has been considered and rejected. Right. So far as the submission of the learned state council relying on the judgment of the Supreme Court, that since the respondent has been serving for last 6 years, they should be allowed to continue. This court is of the view that in view of the settled position of the law, that there would not be any excess appointment over and above the law, over and above the first advertised. This court is unable to accept such submission, as in those cases relied on the learned counsel with the parties, the estate respondent, is by the Honorable Supreme Court by exercising the power under Article 142 of the Constitution of the next para. Regarding head to the issues regarding head to the issue which I had analyzed above, and in view of the law laid down by the Honorable Appeals Court, this court is of the view that the writ petition deserves to be allowed. On the ground, on the deserve to be allowed. List of no. It is of the view that the selection and appointment over and above the advertised post of 38 candidates deserve to be interfered. However, the selection and appointment, selection and appointment is not interfered, but only the excess appointment above the 37 post advertised needs to be interfered. Accordingly, the appointment of the person appointed access the post is hereby satisfied and clause, and the same shall be advertised and accordingly, will not say satisfied and it is this the liberty is granted to the respondent to fill up the post in accordance with the law. It is made clear that this court is not interfering with the selection process as such. Accordingly, in the result, the writ petition is disposed of.
Listen.
After 3 weeks.
2 weeks.
2 weeks. Huh? Ready?
Consensus.
Consensus.
Yes.
On the consensus of the learned counsel for the parties, list this matter after 3 weeks.
Please, Your Lordship, on
Yes.
behalf of in Kim Song additional AG Lordship. Lordship, let this matter come after 2 weeks, Lordship.
118, 118. 120.
120.
Mr. On the prayer of Mr. Mr. B. Zemomi, learned counsel for the State Council submits that Mr.
In Kim Song,
Im Song,
additional AG, Nagaland.
what happened to him?
Lordship, he has applied for the leave note, Lordship. He has applied for the leave note.
You have no objection.
Lordship, we have no objection, Lordship. In fact, Lordship, this honorable court has directed us to seek some instruction, Lordship. However, we are yet to receive the instruction. Lordship.
Okay, and then on the prayer of learned counsel for the petitioner as well as the respondent, list this matter after 3 weeks.
Lordship. Lordship.
What is this?
Well, is with regard to.
Can you finish it up 30 minutes?
Well,
Can you finish within 30 minutes?
Lordship, I'm mentioning on behalf of additional AGB software, Lordship. I pray that this matter come after 2 weeks.
Urgency is there.
actually,
You are here or you are from Gauhati?
I'm from Dimapur, my lord.
Dimapur.
Yes,
You are from here only then.
ma'am.
Because we'll hear you and then plus it's taking time and not possible to complete. All right. On the prayer of Mr. B. Sokri, learned addition lazy. And prayer not being objected to by Mr.
MK Muhammad.
Learned counsel no decree. And this dismissed after 2 weeks.
Ma'am.
Item number 127.
After 3 weeks.
My lord,
After 1 week, my lord.
it's short payroll basically.
Huh?
It was a short payroll after what, a week, my lord. After a week,
After a week.
yes, my lord.
That means after 29.
Yes, my
Yes,
lord.
my lord.
On the prayer of the learned counsel for the purchase, list this matter after a week.
Item number 135 to 139.
This is what mention was made.
Compensation.
Ah.
Lordship, if this matter may come after 3 weeks.
Yes, Lord. No objection.
Mr.
Chimai,
Learned counsel for petitioner.
petitioners.
Praise for listing the matter after 3 weeks. List the prayer not being objected by learned additional AG for the
So-
state
R1, 3, 4, and 5, Lord.
and also Mr. Moajamir for
Number
respondent
6.
number 6. You have no objection.
No.
Prayer is allowed. List this matter after 3 weeks.
Item number 141.
It was possible.
Lordship,
To complete.
I'm just seeking for advertisement, nothing for myself. So it,
Can I dispose of?
yes, just a short matter, Lordship. This honorable court directed for advertisement of the post.
Yeah.
However, without advertisement and without putting up even in the board of the department,
So you file the contempt. Why petition?
that is also one thing, but Lordship, I'm just seeking for
You cannot. What is the order of the last order of this court? Last order.
Lordship will kindly come to page 21. First page is 15. Oh, no, 14.
Operative.
Operative portion is, it's very long, 14, paragraph 14, Lordship. Allow me to.
It is post of what?
Lordship,
Post. Name of the post.
name of the post is Chokidar.
Why pass order after order? And that too is a division bench order.
Lordship,
Single bench, as you know, is not a implementing agency of the division bench order. It has to be implemented and complied by the government only.
yes, Lordship, but here the problem is, if my lord will kindly see
Section
page
20.
24.
Section 20.
Page 24. The government, after the disposal of the writ appeal, directed the engineer in chief. Page 24. Second, you are requested to advertise the post for appointment as per the existing government guidelines, and when ban on appointment is lifted by the government. At that time, there was ban on appointment, Lordship. So lifting of ban was done on 20. Subsequent development has taken place, Lordship. That's why new cause of action has arisen. 27 May 2022. Lifting of ban on appointment.
Where is your reading? Where you are relying? Page number?
25, annexure D. This is lifting of ban on appointment to group D employee. Then instead of doing that, the petition, this was also annexure E, page 26, was not served to the petitioner. And it was sent through WhatsApp message to his brother-in-law. Kipuri is very remote place. It takes 2 days to travel. But this was received on 8 August. This was sent to his WhatsApp through his brother-in-law, and
Page 25.
page 26. The calling letter. Then
You are the petitioner.
I am the petitioner, Lordship.
This is calling letter.
This is the calling letter that was sent to my brother-in-law. So, so it was issued on 8 August, and the next day it was sent to my brother-in-law, then to appear before the calling letter on 11/8/2022. So even the traveling takes 2 days, Lordship, from Kipuri, remote Kipuri, traveling to Kohima.
8, 9, 10 days. You'll reach here 10 evening. 11 you could have appeared.
I appeared.
Okay,
And in the morning, we reached through night bus, Lordship.
okay.
Now, straight from Kipuri, traveling from Kipuri, I came and they asked me only my name. And when did you come? Only that was asked. And that, since I don't know, I inquire about the proceedings, and there was no, even the notice was not on the blackboard. And when I inquire about it, the establishment office called me into their establishment and gave me the notice. It was not even put up, they put up in the notice board of the department. However, this honorable court has directed for advertisement, Lordship. So notice is not an advertisement. And the honorable court has directed that I should give application. If
Now, what is this thereafter?
thereafter,
What is this?
Every-
Page 20,
27, they appointed this person, respondent number 4.
after the interview, after,
After that, morning so-called interview, Lordship.
so according,
I was not even allowed to apply. I did not apply. The honorable court's direction is very, and this action is very adverse. The manner in which
you are found to be not qualified for the post after the interview. Is it so?
Lordship, that is what in their annexure they have written like that, but
Page 28, what is page 28 again?
this was issued on 28 July, where
So will be to be conducted,
this is the notice.
okay.
This is the notice.
After the interview, this page 27, this is the impugn order.
27 is the impugn order appointing the respondent number 4. Without advertisement, Lordship. Notice, this notice is not, here I'm before the honorable court, this notice is not an advertisement. And this was given to me personally by the establishment. It was not even put up in the.
Madam, it will require some, determination. It's not as easy as you have projected. Right? Isn't it? Number one, there was already order of this court.
Yes,
Division bench.
Lordship.
Number two, you were asked to appear.
Yes, Lordship.
You appeared.
I was
What
on,
happened, what thereafter, we don't know what happened, and you also don't know. The respondent number.
was appointed.
Was appointed.
And when there is no advertisement, how these people.
So what is the stand of the government?
Calling notice was served to the petitioners, to the private respondent as well, Your Lordship. And both of them appeared the interview conducted
Why
by,
only both of them?
no, not only both of them, Your Lordship. There were as many as 6 candidates.
So how did those apply without advertisement, Lordship? That is my question before this.
Your Lordship, the issue here
It
is
was not even tested in the departments.
whether the petitioner has appeared the interview or not, Your Lordship. Whether the petitioner has
You come to the.
According to her, issue is whether there was an advertisement or not.
Yes, that is all.
Okay, Your
The
Lordship.
direction of the court.
Then in that case, Your Lordship, the same process was conducted and the petitioner has been successful. But the petitioner still come back to the court and say that in that case,
Once appointed,
Assumption cannot become a assumption cannot be a.
she has already taken a calculated risk. Now, what is the tax code says about the Your Lordship? A person appearing the interview, failing. In the last case, Your Lordship is very clear.
but
Interview is not
if there is a glaring illegality,
Lordship. That is.
court can always interfere.
So where is the illegality, Your Lordship?
This
Advertisement.
the person-
The direction of the court.
Lordship, what does the
I
court
would
say?
say pick up 3 or 4 persons, or for that matter, 2% or 10%.
No. Allow me to read
The operative part of the order of this court. It clearly says, Your Lordship, if I may be allowed to read. Page 21, Lordship.
Yes, Lordship.
The only operative part, Your Lordship, only the operative part. Yes. It is needless to say that the competent authority of the State Public Work Department would pass appropriate order to set aside, receive the order of the private respondent number 4 to the post of Chowkidar, and that the state government will.
Same person.
Yeah, this is the same person.
No, same person.
This was terminated. I'm looking for terminated, Your Lordship. Yes. And will take a transparent means to fill up the post of Chowkidar in the establishment of executive inspector prayer division, so that the applicant, Your Lordship, so that the applicant also get an opportunity to apply. That's why I said if he is otherwise eligible to apply, she applied, Your Lordship. When? After that, how was the polling letter issued to her, Your Lordship? It was through WhatsApp, and that was also within 2 days. That content of the petitioner, Your Lordship. What is the difference? Lordship, Lordship, kindly come to Annex 32I. This is the way advertisements are made by the direction of this honorable court.
Okay,
There are so many, I'm just a sample of it.
as for instance,
Instance, a sample to substantiate.
very bad, do it,
Lordship.
advertise it. Anyway, we have paucity of time, we'll take up some time.
Tomorrow then, Lordship. After all, it's already almost finished.
No,
This is, I start to
Please.
argue.
no, I just had cursory glance.
The manner in which this was done without even testing in the blackboard.
But
I
the
was-
problem is, madam, you have appeared, you have received the notice and you have appeared,
Notice that was sent to another person, not to me, Lordship.
but then you have appeared.
Oh, so straight from the my traveling, because I was asked to go
Okay.
to, I was asked to go to
Of
the
course,
office.
you had a hope that you will be considered when you have
Of
been
course,
asked to
Lordship,
appear.
if my lord will go kindly, here it is very complicated. The petitioner does not have the resource to approach the Supreme Court or whatnot, because she is an indigent person.
No,
Otherwise, I am the landowner, Lordship. I am the landowner who has not even availed one appointment. But you know what, in the division bench, this is something absurd, where our wife will say that you are not since you are not the father, you are not, that is very absurd, but Lordship, this is very perplexing. I
You-
cannot say.
so you could not approach the Supreme Court.
No,
Had
no,
you been had a resource or?
no resource, no
You
resource.
could have approached the Supreme Court, that is what you are saying.
That is also one aspect, but also I, as a wife, has denied the relationship between the children, the husband and the wife. What is the difference there? I am the landowner, I applied for it, and it is said that since I am a woman, since I am the mother, not the father.
So this matter involves a very emotional.
Even emotional,
issues.
high emotional.
Court is constrained not to take up this matter.
So, Lordship, just I'm seeking for
Anyway,
advertisement.
After 2 weeks, you try it, or next week we may try.
Next week, Lordship.
Because
A specific time, maybe.
today I have seen, to be frank, today, this call here, 142 meters. Of course, all maximum adjourned, but it is not practicable. It's not practical.
Monday or
All these matters to be listed for adjournment.
Monday or Tuesday, Lordship.
Lordship,
So it has been,
Monday, Tuesday, Lordship. Many of my matters have already been fixed, Lordship, and
So after 2 weeks,
yes.
after a week, all right?
after a week.
Huh.
A specific time may be given then on
No, it's
Thursday or
okay,
something.
you decide. On the prayer of them, due to paucity of time, huh? Just
Wednesday, Lordship, Thursday is holiday, it seems.
so and so.
Wow.
No,
after.
the petition. And also had both the record their names. And Angami for state respondent, Poseko Pote for respondent number 4. I don't want to set as one more appointment of your client. So, take after 1 week, due to paucity of time. matter could not be taken up, list this matter after a week.
Lord. Lordship.
Over.